Is he still on this matter as far as you know, Mr. Zandy?
That is my understanding, yes.
Okay. Well, I note that this is a review hearing that was set 2 months ago-ish. Nope. Let me strike that. It was set 3 months ago. So June 13th, there was a review set to be reviewed today to determine how the schedule was going and to see if there would be any additional implementation of overnight visitation. And nothing's been filed since that order.
Correct. And my understanding of this and pursuant to my communications with Ms. Bliss is things have gone very well. And we haven't received, to the best of my knowledge, anything in opposition of bumping the time up for visitation with my client who's currently enjoying day visits only. My understanding again from the June hearing was that the court was going to contemplate pushing those to overnight visits, which certainly seems appropriate given the circumstances. That's going to be our request. Our client does have a little bit of a peculiar work schedule, but again, that's been fleshed out at past hearings. What we're essentially asking is just that the day visits extend to overnights, which would result in Wednesdays overnight to Thursdays, and then on his weekends, Saturdays overnights to Sundays. Also asking for some time, as it seems odd, but the holidays will be here before we know it. Also asking for some time at Thanksgiving, the 24 to 48 hour period for that holiday, as well as some time on Christmas Eve to Christmas Day, or alternatively, whatever my client can get over the winter holiday would be very much appreciated as well. That's the request. I think that was part and parcel of the arguments back in June. The court wanted to see how those visits were going, and by all indicators those visits are going very well, and it's time to advance a little bit.
Do we have Gabrielle Evans present? All right. I have some concerns moving forward when the other side's not present. I'm not opposed to hearing it. I don't know, Mr. Zandy, if I call in a matter you're not involved in, would you be willing to try to reach out to Mr. Swenson and see why he's not here?
Yes, I will certainly do that. I'll mute myself and come back hopefully within the next couple minutes.
Perfect.
Your Honor.
Good afternoon. How are you?
Good.
And good afternoon. Can the court hear me all right?
I can.
Okay, thank you. I'm just having a problem with my video, but otherwise I'm present.
Okay. All right. So we're on. I have a presentation of order and a motion to compel that we're on for, and I do have proposed orders, an order on hearing from August 29th and an order compelling answer to discovery. So those two orders I've been provided with. I did not see if we start with that order from the order on hearing from August 29th. I didn't see any written objections. Ms. Jeffers, any concerns with this order being entered?
I don't know what order you have in front of you, Your Honor. I signed, excuse me, I signed an agreed order that was supposed to go to the court, but I can't see what you're looking at. I don't know if that's it.
So I believe that Ms. Jeffers did sign off on the form of the order and we sent it over. We would have sent prior to her signing both orders in preparation for today over. But I believe Ms. Jeffers has already signed that order. So I would just not do the presentation and that order will just get signed in due course. It might have just been in the ex parte box since it was agreed.
Right. So the order on hearing that I was provided for August 29th, 2023, I will set aside, assuming that there's an agreed order that's coming or may have already been signed by a judicial officer. Okay, so then we're just on for the motion to compel this.
Yes.
All right.
So in this matter, we have filed a motion to compel in this matter and filed a relatively lengthy declaration attached to that. We did provide sort of point by point the specific requests and the objections that were the result of the CR26I. We filed that. The vast majority of the objections that were made were not valid. They just simply were not valid. They are not legal objections. And so at this point, the response was essentially at some point or by now, counsel stating that she would have filed a motion for protective order. I have not seen that. It is certainly not docketed. And so where we sit today is just the reality of these materials need to be provided. I think there is significant frustration, and a lot of the materials that were requested are clearly not privileged, are clearly relevant. There was admissions to their relevance and still refusals to provide that necessitated the motion to compel. I think that's frustrating, especially in a case like this has gone on so long, when you have materials that are relevant and one side sort of is repeatedly blockading. And I think that the history of the case is somewhat relevant when we look at this very long-term reunification that's gone on, a case that's really been pending now for quite some time, and one party just repeatedly sort of doing everything possible to throw up roadblocks towards completion. And so that's certainly frustrating. It's not appropriate in this matter, and it's causing undue delay and undue prejudice to my client, and not being able to prove his case and not being able to move the case forward. And the reality is the child suffers. The child suffers when we delay and we don't get cases completed. In this case, I am asking the courts to order the materials to be provided. There's no valid objections that have been provided. The court should across the board say provide the materials that are requested. The court should set a due date for when those will be provided. The court should set fees and the court should set sanctions. Fees should be substantial. And I think a sanction is appropriate given the fact that the objections just simply weren't valid. Second, I will relay to the court that this morning, at what is most assuredly the 11th hour, I did receive some materials from Ms. Jeffers' client. There remains objections where they're still saying we object. Those objections remain not valid. Some of the objections are, well, Mr. can obtain these himself. That's not a legal objection. So again, we sort of remain in the same position. So I would ask the courts to enter the order to compel, award fees and sanctions in this matter. It's appropriate. It is reasonable to do so. And the materials that are requested are very relevant. We did our best to time limit them to reasonable time periods. Essentially from focusing really on the pendency of this case. If the court wants to time limit some of the other requests, fine for the court to do that, but that really wasn't even their response. Their response is just a generalized, we're going to file a motion for a protective order. So I think our request is pretty straightforward. We'd ask the court to grant it.
Ms. Jeffers.
So, Your Honor, the 26I was requested by me for the purpose of a protective order. That's all we discussed. We didn't discuss what material I had, what I didn't have, when I'd be able to review it, or a due date. Otherwise, counsel would have been aware of my litigation obligations. At this point, we talked about some scope, discovery. I did provide some discovery within that scope, and Mother had the discovery to me. The problem is there's too much to review. Google, Facebook, basically there's no limit on time or scope. It goes back a significant amount of time. Every video watched, every place where navigation was ever used, every search ever conducted. It is significant. And the reason that the protection order has not been requested at this point is because some of the information is also privileged. Until I go through all of that information, I can't bring an effective motion for a protective order. And it is significant. I anticipate the protection order once I review the completed materials, but I have been in extensive litigation over the last month that has prevented the time necessary when we're talking about, again, information starting when Google started, basically. And quite frankly, some of the information may need to be subject to a subpoena based on my contact with some of the phone companies and things like that, and the date ranges that they're able to provide. So at this point, that's where we are.
Very briefly,
Yes.
that's none of what counsel said is a reason to not provide. So privileged materials, that's what a privilege log is for. That's very straightforward. But none of the materials of the child's are privileged whatsoever. That child doesn't have any privilege. There's none to assert, and Mother can't assert for him. Counsel's assertion that, well, gee, maybe there's some stuff we have to subpoena. That means they don't know yet. They haven't even attempted to obtain those materials yet. So as we sit now, they've not gotten them. They've not attempted to get them. It's just, well, I'll get to it when I get to it. The purpose of a CR 26I is to go over the interrogatories and requests for production and try to make agreements on what will be provided and what won't be. When counsel just generally makes blanket, I'm not going to provide it, there's no point in me setting a date. Yeah, I don't have to set a date for something counsel says I'm not going to do. That's the purpose of the compel. So it's reasonable to come forward then with a motion to compel when counsel says I'm not giving it to you regardless of the date you set. So the purpose of the 26I is simply, it's a meet and confer about discovery. So as we sit now, counsel's not telling you what she has, when she'll get it, when it was requested, none of those things. They have an obligation to this case that has been pending for a long time to move it forward. And the objections raised are not valid. There's no protective order filed as we stand, and no real valid reasons why a protective order would be issued. If there's privilege in the materials, counsel can file her privilege log along with the materials that she provides.
And I just will say, Your Honor, that I provided the child's information to opposing counsel. So I'm not quite sure where she's going with that.
Okay, so I'm reviewing some of the requests that are laid out, at least in the motion to compel. Some of them, I see a lot of them have 3 years since January 1st, 2021. 3 years since January 1st, 2021, since January 1st, 2022, not since the beginning of Google. So I'm going to grant the request for the motion to compel. I am going to give you more than 10 days, since it sounds like you've been in trial extensively recently. So I'm going to give you more.
Yeah.
I'm going to give you 20 days from today. I'm going to impose, and I don't like doing it, but I will impose a $500 sanction and $500 in attorney's fees. I know that's drastically lower than what's requested. That's what I'm willing to order at this point. So I've signed off on that, and I do not. We have a final review for GAL November 7th. I don't know if we need anything else set in the meantime.
I would just ask that we just add into the order to compel that we'll review it at that same time. I'm fine with the November. That's 20 days and essentially 20 more for us to suss out anything that sort of remains. But I don't want to just leave it without a review. Some folks argue that there needs to then be additional motions. My client shouldn't have to pay for additional motions to be filed.
Well, and Your Honor, I'm still going to have to bring a motion for a protection order. I mean, that's where it is.
Okay, I've included that this will be reviewed no later than November 7th, 2023 at 1 p.m. So
Okay.
If the protective order happens before then and needs to be noted on, then it'll need to be noted on. Order.
Thank you, Your Honor.
Yes, Your
Thank
Honor,
you,
I
counsel.
present for
Good luck.
Mr. Gronitz.
All right, I don't have an order. Did you submit one?
We did, yeah, we submitted, I believe, last week. I can resubmit them. We did send them to her right after the hearing, so she's had them for a couple of weeks, and we've not heard anything about these orders. I understand she's filed separate documents about something else, but we received no response to the form of orders.
I have not seen any either. Madam Clerk, do you have any knowledge? I only got 3 orders for today's.
Uh-oh. I can have my
We
staff
didn't
go ahead. Oh,
receive
sorry.
any paper orders.
I apologize, Your Honor. I thought my staff sent them last week. Would it be acceptable to email them over shortly after the hearing, or what would Your Honor prefer?
Well, they've
Or
already,
can
I do show proof of service. If you want to just resubmit them the same way you submitted them last time, and then those can be sent back ex parte. There's been no, the only response that's been filed by the respondent in this case has nothing to do with the order that we're entering today. So I think we can, I feel comfortable, and there's proof of service in the file that we can enter those ex parte at this point. Saying that last
Okay,
name correctly.
great. I will have my staff submit those. Thank you.
Is it hold? Thank you.
Yes, sir. We have it is just Camper. I think Cold is a prior last name.
Oh, sorry. Okay, Camper. I'll make a note of that.
And we are representing the petitioner, it's the original petitioner, Ms. Camper, in this matter on a show cause by the respondent, along with a motion that's in the file that doesn't appear to be reflected regarding preventing a relocation.
Okay, so when I looked at the show cause, it was not involving the other parent with the change in school. Am I wrong about that?
Well, Your Honor, this is Ms. Pawlowski, and I represent Mr. Phillips. We have a contempt motion filed and set for today, as well as the motion regarding the move.
All I show is the show cause on. So
There was the motion regarding the move, Your Honor. I don't know if it didn't get put on because going through Odyssey, there was no objection filed regarding the relocation. So without the objection, it may not have been reflected as noted on. They kind of go hand in hand, in all frankness. My client in this case relocated with notice to father, and that necessitated a change in schools because she's the primary residential parent. So they do somewhat go together. The defense to the relocation, the defense to the contempt is the relocation, given the percentages was presumed to be allowed. And so I don't know if the court has reviewed all the materials and is able to proceed today, or how Ms. Pawlowski would like to proceed in light of that. But I think they do somewhat go together under the circumstances.
And Your Honor, my client did file his objection timely, as well as his motion. I think the issue, what's going on today here in particular, is unilaterally, the opposing party, without getting too much argument, our understanding has already moved these children and changed schools. And so we're on the cusp of school starting, if not already starting. So this was already moved previously a couple times. And so I do think it needs to be heard.
I'm not suggesting otherwise, ma'am.
Okay. I just want to make sure that
I'm just telling you what the clerk's notes say it's on for, and it's just on for a show cause contempt today. But I do see that there was a motion for a temporary order preventing a move, and that was noted to the docket at the same time as the show cause. So I've reviewed everything. I'm prepared to move forward.
Okay, that's great, Your Honor. That was just my next question, if you did review everything, because I think opposing counsel and I would like to have everything heard at the same time. I think it makes the most sense.
All right,
I
let's
agree.
go.
Okay, may I proceed then, Your Honor?
Please do. Yes, we have a big docket.
Sure. Thank you, Your Honor. May it please the court, counsel, and I see that both parties are here. Your Honor, as you can see from the file, Ms. Camper, she filed her notice of intent to relocate, indicating she was moving on 7/13 of 2023. Mr. Phillips, as you know, timely filed his objection to the move and scheduled a hearing. Later finds out, you see from the written documents, that Ms. Camper had already moved prior to even her indicated date that she was moving. So that in of itself is a problem, that she's telling this court and telling everyone, giving notice that she's moving at a certain time. And she's already moved. She's already moved by that time. Furthermore, she unilaterally disenrolled the children from their school district. My client finds this out. He frantically calls the school, asking, please do not disenroll, keep our children in the school district, which I'll get into, but as you can see, the reasons why he does not want these children removed from that. We also know she admits that she went ahead and has already changed the medical providers as well, has already had appointments with new medical providers, and trying to justify that. The parties have joint decision-making regarding education, joint decision-making regarding medical. None of this should have occurred. I think that the contempt portion of this is blatant violations. If there was one, she didn't even consult with my client. Two, if there was any sort of disagreement, her option then is to come to court and have the court make the decision, not just to say, well, I'm doing it because I'm moving and I think it's in the best interest, which is what you can glean from her declaration, or, geez, he doesn't agree with me, so too bad, so sad, I'm doing it anyway. That's not how it works. So I think that the contempt is clear. Moving on to the relocation, as you can tell from my client's declaration, first of all, Ms. Kemper, I think, says, oh, he's known I've been wanting to move for quite some time. And my client says, at some level, yes, but it was never a discussion that it would be anywhere other than someplace in town. And he always got the reassurance that nothing would be affected if she moved somewhere else. And even when she says, well, I have some text messages that says Castle Rock. My client says, no, we had conversation about that. And you said essentially that those were only houses that my realtor wanted me to see. So I knew what was in my price range and I knew what was outside of my price range. And I was looking at all sorts of houses. And he had conversations. He says, as soon as he was provided with the notice and it said Castle Rock, he immediately started contacting attorneys. And then we came to court on the relocation. Now, I think you can probably also glean from my client's declaration that the move itself may not be as big of a concern in terms of, hey, she says I'm only moving. It's not that far away. It's not like it can change everything up, but in essence, it really does. And the most important things that it changes up is not only as she wants to change the medical providers, which my client says, please don't do that. This is who they've been seeing. This is who they're used to. There's no reason to do that. There's no basis for this, as well as the sports. But the most important thing is the school. These children have been through a very unusual circumstance, which I think was laid out in detail, where Ms. Kemper had already moved the children to a certain school district at North Lake. And then there were very significant issues where both children were being assaulted there by another child in an IEP program, completely traumatized. There was an investigation by North Lake, by Longview. It was eventually determined that the parties' children were the ones telling the truth. Of course, you see the school districts kind of probably scrambling to fix the situation. The end result was they offered the parents your choice of whatever school that you want these children to go to. My client tells you that both parties together made a decision that they would go to Columbia Valley Garden School District, to that school. That was the #1 school that offered the best support for them. And of course, moving these kids so many times with schools caused some struggles. And these kids struggled the rest of that year to do well in school, to get to a safe, comfortable place, to make friends. Finally, after all of this trauma and drama, they eventually get to a safe place. They eventually get comfortable. They have friends. They're doing well by the end of the school year. My client says there is zero reason at all to now switch schools. This makes no sense at all. This is going to be further traumatic for our children. They finally got to a place where school is a scary place for them. School is a place that is generally not stable and causes problems for them. They finally feel comfortable. And now Ms. Camper, because it's convenient for her or because of her own desires, wants to place the best needs of the kids aside and wants to move them, and quite frankly decided to unilaterally disenroll them. My client says, please, if you allow her to move homes, which it seems like it's going to happen because she's already purchased a home, there's no basis for them to have to change schools because they've already been allowed that opportunity to have that school. This isn't a situation where it says, hey, you move, you have a new residence, you now have to go to a different school. We've already bypassed that. The school district already said, you're in this school, you're staying in this school, doesn't matter where you live because we've made this accommodation for you. And my client is saying, don't let our children have to relocate schools again. There's so much going on with them right now. And the last thing we want is to cause problems again and to completely upheave their stability that they have. And so my client is asking that at this point that you keep them in the same school district that they've been, same school actually, CVG, and also to not change their medical providers. There's no reason for that. He wants them to stay on the same sports. It sounds to me like they can be in the same program, but on a different team. My client says they've already made friends on this team. They're already used to going to these practices. The last thing we want to be doing is changing every single thing up for these kids. And it seems like that's what Ms. Kemper wants because that's what's convenient for her. And I think you could tell from my client's declaration, he's trying to find a middle ground that makes sense relative to what's best for the children and not necessarily best for the parties. And the last word, he also says that if he has to be going to a different school, that also is going to make these children have to get up when they're with him at 5 a.m. to get him to a whole different school and to be able to get to work on time. And that in and of itself is also going to disrupt this children's schedule and completely change everything. He's asking that you not do that. Thank you.
Thank you, Mr. Baldwin.
Yes, Your Honor. So there are two issues before the court. Contempt specifically related to an accusation my client violated joint decision-making with regard to education. I think it's a misstatement on what joint decision-making means or relates to in the context of a relocation. That's why that issue, I think, is paramount to address in some way, shape, or form first. My client is the primary parent with whom these children reside the majority of the time. The secondary declaration, responsive reply declaration from the father indicates 10 days a month. That is his schedule. The existing parenting plan is Thursday to Monday and Thursday overnight to Friday in the off week, 5 days overnight every 2 weeks, 10 days a month. That does not relate to a 58-42 plan. That's about 66-34% with my client having the majority of the parenting time. I think it's important to note in the context of the concern as it relates to the children getting up and spending extra time transportation to school, because they live with my client the majority of the time, the majority of the school days, it is a much greater imposition for them to be rousted on 2/3 of the school days to go to school in Longview. Something at this point, because father lives in Kelso and mom no longer lives in Longview School District, isn't even practically possible. My client, in her declaration acknowledged by father, provided notice first via text message and then followed up with a certified copy. It was attached to her declaration that there was return receipt or certified. It had the tracking label to indicate that it had been picked up on the 22nd as identified by father. She had been in the course of trying to buy a residence for more than a year and a half, and throughout the process had on multiple occasions over the prior year plus informed father that there was the plan to purchase a residence anywhere between basically Castle Rock and Woodland. In her declaration at Exhibit D, there's a text message between them on June 14th where she had confirmed they finalized on a home. In her declaration, it indicates prior instances where they were close to having completed the purchase and not been able to do so, that until they actually closed because of contingencies and other issues, she didn't know for certain the move would happen. They had other residences fall apart at or shortly before the final closing, that she informed him they closed on a residence in Castle Rock. His response, Castle Rock, what happened to not moving out of town? Her response was, Castle Rock to Woodland was what I always said the border would be, which is reflected in the text messages. Father claims in his declaration that she assured him after every one of those text messages that the plan wasn't really to move to Castle Rock, that there are multiple periods and multiple times over the year prior where she was looking at residences in Castle Rock, and none of that occurs in text messages. So I think it is something that at best should be taken with a grain of salt, that despite looking consistently in Castle Rock or in his own declaration, being informed by a friend she was looking in Cass Lamet, that he didn't have reason to know that the plan was for her to move in a way that didn't affect his parenting plan, but could affect ultimately where the children go to school. Her response wasn't in any way, shape, or form an indication of desire against what's best for the children. What she said in the text message that's attached is, this was always the plan. I know it'll be an adjustment. I'm sorry, but being out of this town is going to be better for them in the long run. Hint, hint, as you're looking, maybe look for somewhere north so you can stay as close to them as possible. This is not an instance where she's trying to withhold the children or cause any harm to their relationship with their father. She found a house that fit their needs in Castle Rock. He had knowledge of that for an extended period of time. And she told him when the move was planned to be. I guess
let me stop you, Mr. Baldwin. Isn't that the crux of the issue? She told him, this is what I'm doing, this is when I'm doing it, and then it's going to impact the kids and you don't get a say in it?
For the purposes of relocation, Your Honor, this is a situation where with the majority of the time being with mother, the presumption is in favor of the move. And father has to establish some amount of evidence that the move would be harmful to the children, not that it isn't in their best interest. Mom has the ability to move. She provided notice timely, and father didn't file his documents objecting to the move. I say it all. So the statute, 2609480, says that you have to file the objection within 30 days. Looking in the court file, there is no objection. There is a motion to prevent the move on a temporary basis that references an objection to relocation is contemporaneously filed that isn't filed. Regardless, she provided that notice for over a year with no objection from him. She was looking for a place to move that wouldn't change his parenting plan time, but that was within a geographic boundary that would result in the kids changing schools. He made no indication that he objected to that. And in fact, when he was emailed or texted that they were able to purchase a house in Castle Rock, he congratulated them. What is happening here is dad is mostly concerned with what this does to his schedule, because he may have to spend an extra 10 or 15 minutes in the car with the kids a couple of days a week, more so than anything else. So if the relocation is appropriate, and I think under the statute it is, mom is the primary parent with whom the children spend the majority of the time. She provided notice immediately upon the house closing and in written form. Dad didn't file the objection with the court, as far as I can see from the record, although he did make a motion to prevent it on a temporary basis. The failure to follow through with filing the objection, I think that's probably moot. But regardless, the burden is on dad to establish that there's a reason not to move the children. It does not impact his visitation, his time in any way, shape, or form. He cannot and does not show that there would be, under the statutory factors, any basis or justification to prevent the move. As long as mom can move, the children move with her. That's just what happens in this situation. She's the primary parent with whom the children are enrolled in school. She doesn't live in Longview anymore. Dad doesn't live in Longview. Situation is not one where there's any indication in the record that kids could stay at CVG because they don't live in no parent lives in the Longview school district. She enrolled the children at the school that she moved to. Again, until dad filed, there's no indication in the record that he gave her any indication that he didn't want her to move. And even in his own pleadings, it's not that he doesn't want her to move. He wants the kids to stay where they are in school. We maintain it's because that's to his benefit and easier for him. But regardless, if he doesn't really object to the relocation and doesn't see the move as being detrimental, then because the children are with her a majority of the time, the children move with her. And it's not a contempt. She can't keep them in CVG. She no longer lives in that school district. So
another quick question. I'm sorry to keep interrupting you. Was there, when they had to move the children because of the issues that were happening at the original school that they were at, and I apologize, I know CVG is where they ended up, I believe, and where they just
North Lake.
left. Was it North Lake? So I'm assuming they didn't need because it's obviously still within the Longview school district, so they didn't need a waiver or anything admitting them into a school that wasn't within their. What I'm asking is it district? Is it by the city, like Kelso School District, Longview School District, or is the district that they're supposed to be in specific to their area within a potential district? So was there any waiver for them to be able to go to CVG?
So my client's declaration, and I apologize, Judge, I think that addresses on page 3, starting at line 10. The kids moved from their original school, North Lake. North Lake was an ultimatum provided by the Longview School District. Daughter had been assaulted by a classmate on an IEP. After several meetings and discussions, the options were given to either move to a different classroom, but that could result in continued contact at recess, lunch, or to switch schools and ultimately within the school district. They decided to move within the school district. Made the most sense because location, residence, and everything else. There's no indication that because they've moved out of the school district, they'd be able to stay in CVG.
Okay.
Again, dad doesn't live there, and that's because that was my client's residential address in the city that was the basis for the enrollment in Longview School District.
Okay. I read that. I wasn't, well, I guess we don't specifically know the answer to that, but it sounds like it wasn't, there wasn't like a special waiver done. It was just the option that was given. Okay.
And that was my understanding, Your Honor, because it was, you can either change classes or change schools. They changed schools within the district.
Okay.
Because it was not tenable to the parents to be in the same school because of lunch and everything else. I know Ms. Poplowski's video came on. She may have an answer to that, and then I can get back to my argument if she has anything different.
I'll wait for my reply, Your Honor.
So again, the issue here for a contempt is willful violation. My client took every step possible over the course of more than a year to keep father apprised of her plans to move, something that as the primary residential parent, she has the ability to do under the statute. She provided official notice, both via text message and informally upon pleading. that she was moving. There are, I think, internal inconsistencies in Dad's declaration that I could belabor, but I don't know that they're significant at this point with what the primary issue is here. And Dad says in his first declaration that it's a 52-48 split, ultimately admits it's really, he gets 10 days a month, which is less. Under the statute, the presumption is in favor of a move. Dad filed his motion to have a temporary order restricting the move without filing the objection to the relocation. And even in what he filed in his motion, there are certain technical issues that are not adequately addressed. In the reasons for the request, he indicates that he did have notice, but that it was late notice. There's some, I think, confusion in his motion for the finding the show cause on the contempt. Mom filed a notice of change of address in the court file on the 26th to their anticipated new address with a notation on the margin that was expected to happen on July 13th. At various points in Dad's initial pleadings, he indicates that she is moving on the 26th or had moved by the 26th, which isn't reflective of any of the pleadings and not technically accurate. Although I think that does form some of their basis for claiming that the notice was late. In his declaration, he claims to have been served only 5 days before the move, which isn't what actually happened or was intended to happen. As far as whether the move is unlikely to be approved, Dad doesn't allege that it's unlikely to, the court's unlikely to authorize the move. If he's conceding that the move is likely to be authorized, then there's no basis for a temporary order restraining the move. He doesn't dispute the move. He doesn't disagree with the move. He doesn't disagree with the fact she bought a house there. And again, he had noticed throughout the entire proceeding and lodged no objection, even according to himself. He claims that she assured him repeatedly that she wasn't going to move to Castle Rock, despite regularly telling him she was looking at homes in Castle Rock, and that doesn't bear out. He doesn't claim that the children spend substantially equal time with each parent. Even in the best case reading of his accusation as far as parental time, the temporary order says 45% or more is a breakdown. He claims 42% in his first declaration, acknowledges 10 days a month, which is more like 33% in subsequent declarations. Either way, the move is likely to be approved because Mom has substantial time. She did everything she could to provide notice for more than a year of the plan and intention. And even in her declaration suggests that if you want to stay close, you're looking for a place, look up here. We'd love for you to be up here. Regardless, this doesn't change the parenting plan. There's no indication it's detrimental to the children. The presumption of the move results in the move being allowed and there not being a contempt because she can't keep the kids registered in Longview when no one lives there. And there's no indication that that is in any way, shape, or form possible in any of the declarations. So we're asking the court to grant the relocation. Again, I think procedurally, the lack of any objection being filed under the statute would be fatal, but regardless, the presumption in favor of the move for Mom, the move should be allowed. And as a result of the move, the children can't continue to be in school in Longview and there isn't a contempt. So we ask the court to find that there's no contempt, that the move is allowed. This was a long-term plan that Dad had plenty of notice of, both officially and technically and procedurally, and it would be a pretty significant travesty here if Mom were required to move out of the home they bought, or for the children to be enrolled in a school where they have no longer any connections and that they were only at for a very short period of time. My client disputes that it's detrimental or harmful. The children have support where she is. And we're not talking about where she is being in Seattle or Bellingham or Alaska. It's Castle Rock. It's Vader in the Castle Rock School District. It's from Kelso, 20 minutes. And there is no harm or detriment Dad can show. The objection to or the request for a restraint on the move should be denied. Mom should be allowed to have made the move, and there isn't a contempt. Thank you, Judge.
Thank you.
Thank you, Your Honor. I may place the court in counsel and parties. Your Honor, my understanding from my client is that when he called to tell them, look, do not proceed with the disenrollment, that we are going to court on this and this has to be figured out, that there is the ability for the children to remain there. He just has to fill out a form, but they understand what's going on here. So to just assume that that's not an option, I don't think that that's appropriate on behalf of counsel's argument or to state.
I apologize. I just want to object. That's not in the declarations or in the record. So it's evidence outside what's been presented to the court.
Okay. And so Your Honor, I'm just the court had asked, and Ms. Kemper, she doesn't have that information that counsel had argued either in there. And so we would ask that any order that this court make, that we ask that you allow them to stay in the school, so long as that is an option. Obviously, if it's absolutely not an option, then we're kind of stuck with that because of her actions. But I think there absolutely is a contempt. She knew that there was an action pending. She went ahead. She knew she had to get an order. She knew she had to have joint decision making. She didn't do it. If there is no agreement on joint decision making, you come to court. Even if your argument to court is, look, Judge, I'm moved and I have to have them in a different school. Then that's your argument. You don't get to unilaterally change schools. That's not how it works. You don't get to unilaterally change medical providers. That's not how it works. She also tells you she's actually taking them to a new doctor and hasn't even told him or given him the information regarding these appointments. Relative to my client talking about the residential time he has, he also lays out and tells you that is true on the residential time. Quite some time ago, his job schedule changed where he's 4 days on and 4 days off, and he sees the children those full 4 days. So to say, well, the more of the burden for the school is on her, not him, that's not true, because 4 days on, 4 days off means 4 days out of 5 days, 1 week, he's taking these kids to school in the morning and picking them up, because that's what they've accommodated instead of coming back to court to formally change that. They've accommodated that. And there was no statement by Ms. Kemper saying that that's not true as to what has happened with that. So I think that, and to say, well, he's known about this move for a year and a half, for someone to say, well, I'm randomly looking at houses wherever in all these different places, my client is just supposed to assume that you're going to end up in a house in Castle Rock, when he's said, first of all, her discussion was prior to even school. Nothing ever happened to that. He didn't worry about it. Then every time he's ever talked about her, when she said she's looking at houses, he said, so just to reassure, it's going to be here in town. And she said, yes, nothing's ever going to happen. Nothing's going to be affected. And then even after she started saying, well, just more recently, she's looking at places. I have a place to look at in Castle Rock. Then the next time it's a place somewhere else. And he said, okay, well, why Castle Rock? And she says, well, because my realtor is just showing me all sorts of houses. So I get a feel for what's in my price range, what's not in my price range, to help make a better decision. And so once he finds out that she's moving there, he comes to court and objects to it, to say that, well, he was always fine with it and now he isn't. He wouldn't be in court here having issues with it. And again, this isn't about his best interest. I don't think he'd be so adamant about saying, look, he even tells the court, I don't have as much of a problem with the fact that she wants get a house and have a place. I get that. I understand that. But what she's done has now affected other things. And here's the other things. She wants to change the medical providers. She wants to change the sports teams that these kids have been on. She wants to change the school, which is a huge issue. And these kids have had so much disruption recently and so much instability. I'm trying to keep them stable. And what she's doing isn't. And that is the argument he's trying to make to this court. And that is why he's trying to say, look, I'm not trying to change her life. I'm not trying to change what she's trying to do with her significant other and better herself with that. I'm just trying to keep what's best for our kids. And the school in and of itself is the most paramount thing. And I'm asking that we not change that, given the history of how difficult it's been for them to acclimate, to get friends. Then they get physically assaulted. Then they get abused. Then even after the new school they move to, it's hard to acclimate. And they finally get to a point. Now she wants to completely upheave that and throw them back into a similar situation. And that truly can cause some long-term detriment for these kids relative to friendships, education, and their ideas around schooling. And it's just not fair for these children. That's why my client is asking for what he's asking. So we are asking that you find her in contempt. She had no right to do this without agreement. She needed to get a court order on changing medical and on changing schools. And also, Your Honor, there is an objection filed. I don't know why counsel keeps saying there isn't one. There is a formal objection filed in the court. I just looked at it again, has the court stamp on it. And we are asking that you keep the kids in the same school, they not change from that. And that even by counsel's argument, it's not that far away. Well, then it's not that far for Ms. Camper to take these kids to school on her days and to pick them up on her days. And it keeps some sense of stability for these kids. And that if it is an option, that they allowed to remain there. Thank you.
Your Honor, I apologize. There were some questions that I did want to address one thing, and if the court may, my client's declaration regarding physician, that Child and Adolescent Clinic had been set up with the intention of being the doctor on a wait list in September of 2022 with petitioner's knowledge. That's on page 6 of my client's declaration at 5 and 6. So we deny that she's made changes, and that also wasn't in the contempt, I don't believe. And then if the court were to inquire, I don't think either party addressed school start date. School for Cowlitz County did start the week before Labor Day. So the kids have been in school for about 3 weeks. And that was it, Your Honor.
And Your Honor, I just correct, it's Veda, not Castle Rock, is what my client has just indicated to me. And she already admits that she's taken the kids to a new medical provider.
All right. This is a little bit of a mess. It seems that for a while, everybody was able to get along, work together. There were some of the responses that were filed by both parties. Frankly, they were a little far afield. And I guess there's a motion for temporary order preventing move with the children. I understand that I'm sure Mr. Phillips considers that an objection, or I understand Mr. Baldwin's position is not the same thing as an objection. There was no formal notice of move. There was just a notice of change of address that was filed by Ms. Camper. I can understand why she potentially did it that way, because it appeared that that there was a long string of messages back and forth, and that it was known by the parties, what, Ms. Camper was attempting to do.
Your Honor, I don't want to interrupt, but there actually is a formal objection to the relocation in the file that I have a stamp on. I'm not
What
sure.
index number is it?
Let me just pull that up, Your Honor. Hold on one moment, please. I have a file stamp on it that I can submit. I don't know what number it is. I just have endorsed filed Superior Court, July 17, 2023, Cowlitz County, and then has the clerk's name on it, has a stamp on it.
The only thing that I have in the file for July 7th, what could be considered July 17th, nothing was filed in that I have on July 17th, but I have several things the 19th. So I have a notice of appearance that was filed by Matthew Phillips. I have a motion for a temporary order preventing move with children, a declaration affidavit, a motion to show cause for contempt, an order to show cause for contempt, a notice of hearing. All those were filed July 19th, 2023. I don't see an objection.
Nor did I, Your Honor. That's the reason I brought it up. I will say also, Mr. Phillips indicates in his motion that he was actually served the notice of intent to relocate via mail. My client didn't file it. She sent him the original thinking he'd sign off on it, which is why there wasn't an original in the file. So she did actually do the proper form and sent it to him, reflected in his motion not to allow the move, but because she had sent the original to him thinking he would sign off on it, it didn't end up getting filed. So that's just what happened there procedurally.
How long were the kids at CVG?
The entire last year, I believe, unless my client can state otherwise. I think it was last school year. Because she had them in a different district, a different school before that.
Oh, that's correct, Your Honor. At most 1 year. I don't know if they went partial, if it was the beginning of the year or partway through. I don't know that for certain, but it's no more than last school year.
And then prior to that was the other school district. So this will now be the first, about third or fourth school that she's going to have them in.
Okay, I just opened the file attachment just to look, and it does say endorsed Superior Court Clerk, July 17, 2023. I don't know why that's not in the file, but it isn't. So
I don't know why either, Your Honor. I apologize. I don't know.
I don't know if you were able to get that out of chat, Mr. Baldwin, but
I just was, Your Honor. And I do see the stamp. I just did not see it in any way. And I checked all the other items filed around the same time just to see if something had been potentially attached and didn't see it attached to anything either.
Same. I did the same, just thinking, since it was a large amount of documents filed all kind of at the same time. Okay, so this is kind of an unfortunate circumstance because for all intents and purposes, it appears as though the parties have been working together to solve these issues. Parties knew that one side was moving, that this may impact certain things, but hopefully, that it wouldn't impact things to this degree. I think, and the informal nature of how the parties initially addressed this reflects that there was, some understanding of them working together on this. The move to Vader clearly has caused some issues with some of the issues that Dad has raised. As to the move, I think there is a substantial basis to approve the move. So the objection to the move, I'm going to grant the move on a temporary basis. It's already happened. And I think ultimately Dad's not concerned about the move so much as how it impacts everything else. And I understand that. I understand the argument that, well, technically mom's primary parent, 60-40, 55-45, 65-35, whatever the split is, that's great. But that doesn't mean that on joint decision making, I get a weighted amount versus the other party. That's not how that works. I understand that there's a series of events that are going to take place when one party moves, especially from Longview to Vader. That's not an insignificant distance. I agree it's in the same county, and there's it's not Seattle, it's not Boise, it's not Medford, but it's still there is an impact on the parties based on that move. As reasonable as the excuses are for not including dad in those conversations, dad should have been included in those conversations. And I think that's just where it's at. I do agree with Mr. Baldwin that certain things are kind of inevitable on a move. I don't want to sit here and say kids were given, I mean, it does sound like kids were allowed to attend CVG, even though that wouldn't be their home school. And I don't know that they wouldn't still be allowed to attend CVG. They were removed. The dad's indicating that he gave notice to mom to not remove them from that school and put them somewhere else, and said that let's talk about this in court. Mom did what she did. So, and I frankly can understand that as well. But obviously it's going to be an impact. Here's what's concerning. One, we don't know if they can go back to CVG. Two, I don't know. I didn't look at the parenting plan that closely to know what the breakdown is, but if there's a minimum of 4 days every other week, approximately with dad, or I don't know how that's broken up, there would be transportation to somewhere far away, depending on who the kids are with. If kids are with mom majority of the time, is it the smartest thing to have them have to drive halfway across the county to go to the school that dad thinks is the best, versus only have to do that a couple times when they're with dad? I don't know. And I don't know what sounds like part of the moves that happened, dad saying, oh, they're at 4 different schools now. Sounds like some of that was an agreed upon move based on circumstances that were outside of the party's control, and circumstances that were within those schools that necessitated the move for those children. So I wouldn't say that that's mom's fault, or that should be a ding against mom because they've been in more than one school if they've had issues at school. I understand wanting to keep them at CVG if they've been successful there the last year-ish, or year plus, however long it is that they've been there. The medical provider wasn't specifically alleged in the contempt, but the same concern exists for the court. Mom's just as well thought out as and intentioned as it may be. She didn't include dad in that decision. She didn't include dad in any decision about school, where the kids would go, other than, hey, I'm moving here, and I guess that's where they're going to go now. So I'm concerned that there isn't some cooperation on that front, especially if we were to believe dad that he said, hey, hold on, we need to discuss this. And she forged ahead anyway, which is kind of what it appears happens. So while I'm allowing the move, I'm going to make a finding of contempt. Parties need to move as a pretty willful violation. If he's saying, nope, I don't agree to this, and she's doing it anyway, that's not a joint decision that's being made by the parties. Frankly, where that leaves us, though, isn't, I don't think that necessarily the appropriate response to that is, oh, they go back to CVG. If they're with mom even more than half the time, even if it's 51-49, is that the best thing to do? Have them travel more often than not travel to go to school? And they've already been in school for a period of time. So I don't know what I don't know that a monetary sanction at this point is appropriate. And I don't even know if the dad's asking for a monetary sanction at this point, but clearly there needs to be some discussion. I think there needs to be dad's claiming, well, I could maybe file something that says they could stay at CVG. Well, we don't know that they could even go there, if that's even an option anymore. I don't want to assume that it's not, but I have nothing that shows that it is. With dad living in Kelso, I believe, and mom now living in Vader, I don't know what's appropriate, but probably going to school on the other side of Longview, even though it's been a good school for them for a while, isn't probably appropriate. So I don't know where that leaves us, but I'm not going to make any finding of any judgment against Miss Camper, but I am going to make a finding of contempt.
We want to set this for a presentation. Ms. Poplawski, do you think that we can come up with agreed forms of the order?
Your Honor, I just want to be clear. So you're allowing the children to go to the new school, and also you're not awarding any attorney fees relative to the contempt?
I'm not awarding any fees, no. And I don't have enough information to order them to go to a specific school.
Your Honor,
That's it. I think he could maybe go to CVG if I fill out a paper. That isn't under declaration. That's a comment from you. I have no idea if they can go back to school there. So him saying, I want you to force this to happen when we don't even know it's a possibility, I'm not doing that right now.
Your
If you
Honor,
want to set this over 2 weeks and give me more information, I'm happy to make a decision.
I would like to do that, Your Honor.
The 26th at 1 p.m.
Thank
All right,
you.
Your Honor. And I'll just point out that for the parenting plan, as Your Honor was indicating, father has Thursday to Monday 1 week, Thursday to Friday the next, which would just be taking the kids to
That's-
school 3 days
that's
every
not
2
what-
weeks in the parenting plan.
Your
So
Honor, we can provide that because that's not what they've been following for quite some time. It's not what they've.
Well, that's what the court is going to utilize is because that's the court ordered parenting plan. So if that's not what they've been following, then I suggest you file a new amended petition or parenting plan that outlines what actually they are following, because I don't have any reason to understand otherwise.
Thank
right.
you. Your Honor. We'll reset this. Thank you.
So we're not setting it for the 26th?
Yes, we are. Thank you.
Okay, 26th
Thank
at
you.
1.
Good afternoon, Your Honor. Sorry about missing the change.
That's all right. Mr. Zandy's indicating that there is a request to expand visitation because things have gone well from a Wednesday visitation overnight to Thursday, a Saturday visitation overnight to Sunday. They're asking for 24 hours on Thanksgiving and sometime over the winter break. There was nothing that's been filed. I don't know if visitations really, are progressing that well or what your party's position is.
The visits, we haven't had any reports of any bad behavior from Mr. Heinzman during the visits. I believe last time we were here, you ordered a step increase to see how things are going because he was having short supervised visits and there's a history of domestic violence and child abuse in the case. He has been progressing with his domestic violence treatment. He's been at, I believe, 10 hours for 6 weeks. And the question for the court today was whether to increase to overnights. I know there has been, Mr. Heinzman has requested some changes to my client, like trying to swap days and then swap them back, which has caused some conflict between the parties. So I've requested from Ms. Bliss an updated work schedule since he said he was working Saturdays, but then he said he wasn't working Saturdays. But I haven't heard anything about any requests for Thanksgiving or any other holidays.
They were just made today when you weren't here. So is this something that is your client objecting to overnights at this point since?
We're not objecting to overnights at this point. There's no really set parenting plan. This case has only had like temporary orders that's kind of like piecemeal adding things in. So we'd like a set schedule. I've been trying to communicate with Chad Zandy's office to get a set schedule so that we're not trying to switch days or anything like that. And so I don't know my client's position on Thanksgiving, but we're not opposing the overnights at this time, but we need a set schedule or just to follow the same schedule we've been following or one that the parties can agree to.
So I guess with my green light to expand the visitations to overnights, Mr. Zandy, or I guess, do you think Ms. Bliss and Mr. Swenson can work out kind of a temporary parenting plan that can be entered either ex parte or within the next few weeks if we set a review?
So yes, confident they can come to some kind of a conclusion on what the appropriate overnights would be. Ms. Bliss has just suggested that we keep the existing schedule, which is looks like third and fourth Wednesdays of the month. Just make those overnight. So the first 2 Saturdays of the month, just make those overnight. And then again, of course, the request for Thanksgiving and Christmas. That's probably the easiest way to do it. So that would be, I guess, kind of my suggestion for on how we approach that. Looks like Ms. Bliss is comfortable with that, and Mr. Heinzman is too. That's one way to do it given his work schedule. And obviously Mr. Swenson and Ms. Bliss can talk about that if that's any problems with that and coordinating work schedules as well, if they haven't already been.
So Mr. Swenson, do you feel comfortable with that kind of baseline proposal? And then the request they're asking for like 24 hours over the Thanksgiving weekend. Doesn't necessarily have to be on Thanksgiving, but that weekend and some time over the winter break. We currently, I'm closed now for the 26th. The next available date would be the 3rd of October to review this. Or we could set it for a presentation on that date in hopes that you could come up with an agreed order expanding the visitation.
But I have to speak to my client about Thanksgiving and winter break. So maybe we should set this for review. And then if the parties can't come to an agreement, Your Honor would have to make a ruling.
Okay. Well, let's set it. We can set it for the 3rd, or we could set it for a Friday before that, like for presentation, if there's any issues. So we could set it the 22nd or the 29th at 8:45, or the next available Tuesday is October 3.
let's keep that October 3. And then my suggestion would be we just have set that for a presentation. And if there's anything that needs to be cleared up on those holidays, that can consolidate the issues and save everybody time and money, hopefully. Does that work for you, Mr. Swenson?
Yeah, that works for me.
So let's set this for, and then if there's an agreed order, we can strike it, but let's set for 9/3/23, or excuse me, 10/3/23 at 1 p.m.
That is ready.
Thank you, Your Honor.
Thank you.
Sounds great. Thank you.
I have a presentation of order. Order on hearing from the August 8th, 2020. It says 2022 hearing. Is that supposed to be 2023?
It was clerical error. I apologize.
All right. And Mr. Hitchcock, did you receive a copy of that proposed order?
Yeah, and if you remind you, 5 weeks ago, I asked that I get a time to stay in the house. Summer is the best time to sell, so I wanted to stay just through the through June, just to have that on the books in an actual order. Added, as well as I'm not getting to see my kids as often. I'd like to ask for 2 FaceTimes a week.
It doesn't show that there's a limitation on the FaceTime. Was that, I don't see that there was a limitation, so I don't have a problem with 2 FaceTimes a week.
If we can put that in the order, that'd be great.
But I think what we did was we just adopted anything that was not inconsistent with the hearing last month. We reserved and kept that pursuant to the existing parenting plan that was entered last August, I believe. So I'm not sure what that is. Again, that wasn't ordered by the court. I don't have consent one way or the other from my client related to that request. So I can't really offer much assistance on that issue. I just asked that the order I'll talk to my client, obviously, but I think the order should just remain as crafted.
Your Honor, she's moved over 1,000 miles away. I mean, I have greatly limited options to see my kids.
No, I understand the request. It does appear that initially it was 2 FaceTimes a week in the parenting plan, and that looks like Judge Hahn changed it to 1 based on because of the temporary restraining order.
It was initially.
I don't need any additional comments. I'm okay. Thank you. So I'm gonna indicate on here FaceTime will be limited to 2 calls a week. Okay. So that means you can have 2, you can have 1, you can have 2. All right. If they agree to additional, then that's between you, but you get at least 2 as far as I'm concerned.
Thank you.
And there is no, when I'm reading this document, Mr. Hitchcock, there's no indication that says that there's a time frame for you to have to sell the house or anything like that. It's just that you're responsible for basically the mortgage, taxes, insurance, and utilities moving forward.
And again, there's $5,500 in unpaid taxes as well. There's unpaid utility bills that I'm gonna have to catch up. I'm gonna have to pay and then pay to hook up, which is not fair.
I thought at the last hearing we determined there was not any back mortgage due.
There was back taxes, $5,500.
Okay, well that issue can be reserved for trial. Because if that was part of the respondent's obligations that weren't paid, that can be reserved for trial. So I'll sign off on that order, and then I show that we're just on for a review hearing and a presentation of order. So I don't know.
Yeah, I was gonna.
What else we were reviewing today?
That's it. I also wanted to just ask for a bifurcated divorce. This has been really tumultuous for both parties. It's been 3 years since we've kissed. I did put forth a motion, but it didn't get added. I just threw it in this morning to see if we could do it. But I am asking, Megan's moved out of state. I want to move on with my life. I'm religious. I'm not dating seriously. I've talked to girls, but most of the girls that I want to talk to, won't talk to a married person, which I technically am. And I do want to have a bifurcated divorce.
I did see, did you file an order along those lines, Mr. Hitchcock, recently?
I did just today. And I mean, we can come back in a couple of weeks, but it's going to cost more money for Megan. And obviously, I mean, I work Tuesdays, so it's going to cost money for me. But I did put a motion if you are willing to, an order if you're willing to sign that to free me to move on with my life.
Did you provide notice to Mr. Zandy?
Absolutely. I dropped off that in his office.
Mr. Zandy, did you receive that?
I did, and I've got concerns. It wasn't a motion. It was a proposed order in addition to an affidavit that essentially says he wants to date Christian women. None will date him because he's still technically married. So I don't think that from a procedural or statutory standpoint, that's appropriate or complies with that. To bifurcate means you do part of the divorce in one section, you reserve on the other part of the divorce for another section. Typically, we see that with assets and debts, and then maybe and support issues, and maybe a parenting plan. We don't have any of that right now. This is the case where we're still awaiting, and it's been well over a year, the results of the mental health evaluation that we don't have. There's still issues, as you just entertained, about the home, and the assets and the debts with that. So there's really nothing to bifurcate other than signing an order. And if I'm reading that correctly, and again, I just got it this morning, enabling Mr. Hitchcock to go out and date Christian girls as he wants to. I don't think that complies with the statute. I'm not opposed to bifurcating. I just don't know where it gets us. And the request is made, doesn't have a motion, and it doesn't comply with any statute that I'm aware of. So I guess that's my input on that. I don't think it's appropriate at this time.
Your Honor, I don't know why Chad would be arguing against this. It lets his client, she as well, is not dating. It lets her move forward.
Okay, well, here's where we're at. I saw that something came across. It's not an Odyssey. I don't have something in the file requesting that. At this point, if there's an agreement and you can work something out with Mr. Zandy, I know that, are you still working on getting an attorney?
I am. It's not working out very well just because everyone's booked up. Your Honor, it's not fair that I should be held hostage in this relationship.
I guess I'm not holding anyone hostage in any
No, I'm not saying
relationship.
you are.
But I also can't handle motions that aren't noted before me on the docket.
Yeah.
So
I was just trying to save time. I will file a motion and we'll come back.
If Mr. Zandy's willing to agree to, if you want to talk to him about it and he's willing to agree, then I'm happy to sign off on that. And we can go that route. Otherwise, I think you'd need to note it on the docket and make sure that any additional information is filed and provided to Mr. Zandy.
I will put forth the motion.
That's
all right. Thank you, Mr. Hitchcock.
The GAL report, which the parties received last week. My client has reviewed that, as has Mr. Burton. Both have submitted responsive pleadings to that. My clients came over on September 11th, so hopefully you've had the opportunity to review that. It's I know that the notice is short, but unfortunately, sometimes that's how it is with these GAL quick turnarounds. And we appreciate Ms. Hite being timely and thorough in that.
I have reviewed both Mr. Burton's declaration that was filed on the 6th and the declaration from your client filed on the 11th.
Okay, thank you. And I don't know how you want to start with that, Your Honor.
Mr. Burton, I am going to start with you since you filed your response first. Sounds like you are essentially in agreement with the interim report from the guardian ad litem to extend visitation. She's suggesting first, third, and fifth weekends, Friday 5 to Sunday at 5, with the Lexington Chevron as this place of exchange, along with the Our Family Wizard app to be utilized.
Correct. Yes.
Anything else you want to state other than you agree with that recommendation?
Yeah. So I just want to say, I thank the courts for allowing this whole process to happen with the relationship with my son. In line 6, I believe, we'll start line 6. How it's claimed that there have been zero.
Hold on a second, Mr. Burton. Line 6 of what?
Page 2. Sorry.
Of page 2 of what?
Of Courtney's declaration.
Okay, thank you.
Sorry. Where it states that there have been 0 visits prior to the past couple months, but right before, we had all the supervised visits before this. So there's been a total of 16 visits now. So just to kind of clarify that aspect of it. Also, it looks like there's some hesitation with the suggestions of the Friday through Sunday from the other side. Stated that there was an original report back in July to do overnights from Saturday to Sunday, but I would still like to go forth with Friday to Sunday, giving me, more time with my son. I feel like is key to continuing to grow our relationship and bond. And I do have a concern as far as same page 2 declaration where line 17 through 19, where it says his behavior has changed. From my view, I've always kind of noticed Asher the way he is, which he's just a little more rough with playing and whatnot. But I haven't really noticed. I don't really see kind of what, like, how I would be the one to start all this. But he's always been kind of handsy. Not, I wouldn't say acts of violence, but I think a thing too at my house, my daughter's not allowed to watch certain things on YouTube or play certain games on Roblox, for instance. But so we have a certain set of rules. Asher wants to kind of push his luck, I guess. Because he does that at the other house. And
Well, Judge, I would just object to anything that's not contained in the declarations or the pleadings. I think we're getting a little far afield at the point of today.
I would agree. I don't know that I'm super concerned about his behavior. I think this is probably it's a difficult age. Plus, he's going through some difficult changes, so I'm not as concerned with that.
Okay.
But I don't want to completely cut you off. So if there's more that you want me to be aware of, please, by all means, keep going.
Sorry. I guess I think what I would suggest is having some kind of. No, I guess I can't say that. Okay, I'll move on. Let's see. I'm not in agreement with the fact of taking our child to any regular scheduled activities, such as sports that he's in on the weekends. I mean, obviously, I want him to play sports and have fun, but if we have plans per se, such as camping for the weekend, and it's on my time, I feel like I should be allowed to take him with and do such things and not be held to giving up that day per se. Other than that, I agree that I would rather have contact with Mr. Rogers through some type of app. Our Family Wizard's a good one. It leaves no room for error or any such thing like that. So it's easy to document. I've documented everything so far. And I would like that too. So that would be our sole form of communication moving forward. And then that's about it.
Okay, thank you, Mr. Zandy.
And you saw my client's concerns through her declaration. The visits have gone on. The child is hopefully doing well, although as can be expected with a child this age, and nobody's blaming Mr. Burton, but we've got to accept the reality that this is new for this little guy. He's 8 years old. He's being reintroduced to dad, and that's a significant change in his life. He now knows a new family that has been largely absent for 8 years. I think Mr. Burton's own words that he's had 16 visits now. That's 16 visits over 8 years. No overnights. That works out to be about 2 per year of this child's life. So now all of a sudden to implement every other weekend in a standard plan from Friday to Sunday, my client's concern, and it's very reasonably based, is that that's quite simply too much, too fast. She wants there to be a relationship. She's always pursued that relationship. And for one reason or the other, that hasn't happened for 8 years.
So if I may.
So with that.
Sorry.
Are you just objecting, Mr. Burton?
Yes.
Okay.
So yeah, the fact of only 16 and 8 years, I raised Asher since he to the point of 3, and then from then on we split. And there's been multiple forms of communication and quality time that I've spent with him during those years in between as well before we're here. I've submitted all that already to the courts. And
so 16 visits over the course of 5 years, that's still not a lot of visits. So the point being that we're giving this child potentially too much, too fast. My client is readily agreeable, and you saw her declaration, readily agreeable to kick that up and ramp that up a little bit. But again, with some phase-in transition time for the well-being of this child makes the most amount of sense. What we're suggesting is originally what was initially proposed or recommended by Ms. Height in the July 17th report, which is the first, third, and fifth weekends from Saturday at 10 until Sunday at 4. My client's agreeable to, provided those go well, after a period of 6 visits, which would put us out to the middle or late November, ramping that up and making those the full weekends as currently suggested by Mr. Burton and Ms. Height. Again, we're largely agreeable to that. And although, again, the blame is not being attributed to Mr. Burton, I think that's clear in my client's declaration, you're still seeing some of those transitional issues and psychological issues of an 8-year-old going through change. And that is acting out in school, not wanting to go to speech therapy, being a little bit resistant, and behaviors go down a little bit. He's in counseling. Hopefully the counselor will work through that with him. We're confident that will happen. We're confident this is a bump in the road, but nonetheless, it's still a bump in the road that we need to address. My client's proposal makes sense. I think it's logical, and that's what we're asking the court to adopt. Would also comment very quickly on this extracurricular activity notion. Kids like sports. Asher is no different. Asher has been in wrestling. He's been, I believe, in soccer. He's been in those types of activities in which he does very well. He's athletically gifted. That's a source of pride for him. And being a parent is taking your child to extracurricular activities. It's not saying, nope, sorry, we're going to sit on the couch and watch TV because I don't want to take you to that. And that's not in the best interest of the child. Being able to participate and cheer your child on from the sidelines, again, is a valuable aspect of parenting that we would suspect Mr. Burton as well as my client would both enjoy, and the child would take a source of pride in that and having both mom and dad there. My client will forward the schedules, the notices, the event calendars, whatever it is, but we need to be able to have this child participate and have fun with his friends and, again, thrive and succeed in something that he's good at. Finally, as it pertains to this Our Family Wizard app, typically, we see that for parties that can't get along. We see that in people who can't effectively communicate, who can't refrain from the name calling or the type of domestic violence that unfortunately is becoming more and more common. That's not this case. This is a case where these parties don't regularly communicate with each other. They went a very extended period of time of not communicating with each other. My client tells you that she initially went to set up the app until she figured out that it came at a price. And again, it wasn't until very recently that she finally started receiving child support for Asher. So again, trying to avoid every financial cost is important to her. And again, that's logical and reasonable given where we're at in this. And there's really no basis to have an app in place when text message or telephone contacts between these two parties is appropriate and has not been a problem in the past. Regardless of where they're at today, they need to be able to co-parent long-term. They will not constantly be under the court's review. They will not have a GAL hovering over them to make sure things are going progressively the way they need to. And they're going to need to take it upon themselves to communicate like adults for the well-being of this child. The first step is being able to pick up the phone and call and talk to each other about last minute notices involving the child, and that's appropriate in this case. So my client's not going to have any significant issue if you order the parenting app, but at this point, she just assume avoid the cost of that and move forward in the way that they have traditionally throughout the course of the years.
If I may, another thing.
Very briefly.
Okay. First, so yeah, I was only notified that Asher was going to counseling via his new counseling recipient that called. So is there a way that I could be, maybe we could work that out to where before he's actually enrolled into something like that we can talk about it? I wasn't notified until he was already signed up and started.
And there's sole decision making in the existing parenting plan, Your Honor, that was entered back on June 5th. But yes, that's a good point, Mr. Burton. I will let you know everything that I do in the course of that.
Thank you.
So if mom has decision making, obviously she can make those decisions, but dad should be informed about what's going on and be apprised if there's new service providers or any kind of changes to major things. Miss Height, I'm going to turn to you for one moment to see if there's anything that you want to add. I know your report is just a few days old, but you're here and want to afford you that opportunity.
I appreciate that, Your Honor. I do have a final report due October 3rd, so I'll have more information. I did have a chance to visit with Asher, as you saw from my report the other day, and he was, I thought, remarkably comfortable, although we didn't have a long chat. His answers, as I think as part of his language processing, he waits for a minute and then he responds. But it was all positive. When I talked about dad's home, mom's home, asked him some open questions, he had no concerns with me. The other thing that I would just want to clarify for the court, I noted in my report that I would be talking with the school staff, and that was scheduled for after my report was filed. I have done that. I spoke with his teacher, with the principal, with the special education teacher, with his counselor, and even with the office staff. And it was remarkable among all of those conversations that there was no concern about his behavior. I was kind of surprised to hear that he'd had some recent outbursts. None of those staff people mentioned one of those. Specifically said there's no behavior issues. He had not been into the counselor's office for any concerns. His teacher, Ms. Schwartz, remarked that he was doing well with others. It was a surprisingly universal, positive raft of information, which I will, of course, I'll be happy to put more details of that in my report that will be coming. But I just thought that was interesting to note for the court's decision today.
Can I ask one question, Judge? Was that this year? They've been in school for 7 days. Is Ms. Schwartz current teacher? Or is that last year?
That's, and we did discuss that he's only been there a few days, but she evidently really has kind of they kind of have something going between the two of them. You can see that they like each other.
Good. Okay. Thank you.
That's great to hear. It is great to hear. And I think things are progressing pretty well in this case. I do note that back on July 17th, Ms. Height said, do an overnight. And I kind of extended things. I extended visitation by the time frame as far as how many hours, but hadn't started. Did I start overnights at that point? Let's see here. No. Okay. And now not only do we have a second supplemental report from Ms. Height that indicates not only should we do overnights, you should do the entire weekend. Dad, of course, is all for that, understandably so. Mom is not indicating she's opposed to that. She's just saying, well, can we start with the overnights before we move into full weekends? Frankly, not unreasonable, and probably where we would have been had I not kind of extended visitations at our last hearing. So here's what I'm going to do. We are on, let's see, this would be the third weekend of the month, I believe, coming up. So I'm going to say for the remainder of September, first, third, fifth weekend with Dad, and I'm going to say Saturday morning to Sunday at 5 p.m. So 9 a.m. Saturday to 5 p.m. on Sunday. If the child has a commitment to a sporting team, Dad's going to be the responsible party to get the child to those events. If there is a major event or, travel plans to go somewhere else, that needs to be sorted out ahead of time. I guess I don't want, Mr. Burton, I'm kind of directing this at you.
Mm-hmm.
I don't want you to say, well, let's go camping because I don't want to do these 3 soccer games this weekend, because this is important to the kid.
Yes.
Your child seems to do well in sports, seems to be a big part of his stuff. So I want to prioritize those. That's not to say that if you're going to go to Disneyland for a weekend that's pre-planned and worked out, that the child can't miss a soccer game or a football game or whatever it is.
That's all.
That's a different situation than what we're dealing with here. Once we get through the month of October, assuming there's no issues, then starting the first weekend of November, that will be Friday after school to Sunday evening. Hold on. I know Miss Height, Sunday at 5 p.m. So if there's no school on Friday, then 5 p.m. on Friday to 5 p.m. on Sunday.
Keep that first, third, fifth, and then I'll present an order in 2 weeks.
2 weeks is closed now. So unless you want to do Friday. Or if you and Mr. Burton can agree on that order. So essentially I'm
I
adopting.
think we probably can. We communicate relatively well together, I think. So I'll give him that order. If we can't get it ironed out, then I'll note it for a presentation.
And then I am going to add one more thing. I am going to ask that the parties utilize our Family Wizard. There's a lot of fee waivers that you can go through. So you don't, and they're pretty generous with waiving fees on that application. But it has a really great calendaring system. So it'd be easy for mom to be able to kind of upload sporting calendars and all that stuff. So dad knows exactly what needs to happen when it's his weekend. Obviously there's no restraining order between the parties, correct?
No.
All right. So mom obviously can attend sporting events on not her weekend, and there's no reason the dad couldn't on not his weekend. Okay.
Perfect.
If you want to, the next available Tuesday would be the 3rd, Mr. Zandy, of October.
Yeah, I'm fine if we do that. I'm going to have this order probably kicked out relatively soon. By the end of the week, I'll email that to you, Mr. Burton. Take a look at it. And if you agree, sign off and scan a signature page back, and we'll strike that hearing, which I anticipate was likely to happen. And then I will free up that spot on the 3rd for somebody else.
Okay. Just one more thing real quick, if I may. As far as finishing out the month of September, I'm fine with the same old meet spot, but moving into October, if we potentially could meet, kind of halfway. Otherwise, I'd be driving up. I live in Vancouver still, so I'd be driving up to Longview Friday to pick up Saturday for the games and then Sunday for drop off. So if drop off could possibly be how it was stated by Ms. Ann, that it could be at the Woodland Walmart, I would agree to that.
I don't have any input from my client on that, Judge. Again, this child is 8. I think keeping the exchange location the way it is now, which I didn't know that was an issue today, probably makes the most amount of sense. That would be my position.
Well, I'm not opposed to if the parties can agree to a different location. What I'm seeing from Ms. Height is the Lexington Chevron to pick up and drop off. But if the parties agree that on one date it can be somewhere else, I'm fine with that. Otherwise, we'll stick with what's been ordered previously.
I'll talk to my client, get back to you on that, Mr. Burton. But
Okay.
for now, I'll keep that Lexington Chevron. All right. Thank you, Your Honor.
Your Honor, might I ask one quick question?
Sure.
I am scheduled to have a final report for review on October 3rd. Would you like me to do that, or would you like me to put it out a little bit to evaluate the weekend visits? I'm just want to make sure we get the information that Your Honor would like. And also that Woodland, Woodland spot was in that previous recommendation.
Yes, that's what I was.
Oh, and
gonna
then
say.
July one?
Yeah.
Yes.
So
And that's all I was. Yeah.
I'm fine, and I don't want to overcomplicate things. I'm fine finishing a report and having it ready for review on October 3rd. But I just wondered if, since you've put the visits, the weekend visits out, if that would be helpful to Your Honor.
Any position, Mr. Zandy or Mr. Burton?
No, I didn't. Again, I didn't know that was. I didn't know that was an issue today. I thought everybody was good with maintaining the exchange locations at the Lexington location. We're going to be back shortly, and if this is kind of the first step of parenting to see if these two can coexist and make decisions on their own. If they agree to Woodland, great. If not, I guess we're going to need some more input on it. But I don't have any consent or authority one way or the other from my client because, again, I thought that issue was agreed. Nobody made any mention of that in their pleadings.
Yeah, I was just under the impression we were going to see where we were at today and then moving forward decide on more things. So that's why I guess coming up to the next hearing I can bring that up again if need be. But yeah,
Unless
We'll
it's
talk about
agreed, unless it's agreed, we'll leave it where it's at. Unless there's an
Fair.
agreement from mom to do Woodland. And then as far as Miss Height, I'm sorry, what was your position, Mr. Zandy, and the October 3rd? Do you want to wait
No,
and push it out a month?
No, let's keep that 3rd. We'll get the order entered, and then we can. My guess is I'll probably note this up for a MSC here shortly. Once we get the final report and everybody can kind of catch their breath and see where things are going with Asher, hopefully resolve this sooner than later. At which time, we can kind of go over everything and get a renewed sense of what's working and what's not, and change it.
Okay, so that answers your question, Miss Height. We'll keep the 3rd.
Thank you, Your Honor. I appreciate that.
All right, thank you. Temporary order
thank you.
on for today.
Your Honor, this is Ms. Poplawski. The restraining order, I think, is going to have to get moved over. We were unable to serve Ms. Teeters. Apparently, she may have emailed that counsel is going to agree to accept service, but that portion will have to get moved over. We just asked that the temporary one be kept in place until that time.
We've already accepted service. I believe that that's already been provided back to counsel's office. We'll get that filed with the court, and we would object to the continuation of the restraining order.
Hey, hold on a second. Looks like the temporary restraining order and order to show cause was signed on September 1 by Judge Basher.
And I received it yesterday. I wasn't provided notice ahead of time. Nothing. And even though I'm counsel of record.
And we were trying to personally serve her, and we found out that the address that she previously had, she's no longer there. So I guess she moved. It's new to us. And the restraining order just simply prevents her from making allegations to school personnel and others regarding sexual abuse of my client. As you know, he's a school teacher with special needs children. So we ask that they remain in place until it can be heard on the merits.
Well, again, I have argument that I'd like to make about that. And I think directly.
We're either going to hear it, Ms. McLean, or we're not. I mean, it's been granted. And if it's set over, it's extended. That's just kind of the way it is.
Well, I'm asking that it be heard. I don't want it continued. I want to be able to at least provide some at least verbal response on behalf of my client, since counsel felt that it was not appropriate to give me notice, which I would object to. There's So I think I should have been given notice. This has been pending for 11 days and I found out about it yesterday.
Okay. Then,
Your Honor, if there's something in the file that counsel wants to argue from, then I'm happy to have it heard today. But if there's going to be responses that are filed, my client should have a right to provide documentation or written response to that. So I guess it depends what counsel is going to be arguing from.
Well, I would simply ask that the court allow me latitude, given the fact that counsel has seen fit to not give me notice. Normally, I would be entitled to notice. I'm not sure, but to be quite honest, I don't think that the information that was contained in the motion rose to the level of me not being notified on behalf of my client in order to provide responses. And it just smacks to me of gamesmanship when we've already got a restraining order against Mr. Brown in this case, protecting the child.
And Your Honor, the court at that time made the decision to enter that order, and it was indicated that notice was not provided. And so we're not going to re-argue what the court decided at that time. So I think either counsel is going to want to go forward today with information that's in the file, or if there's going to be new information provided today, then it should be provided in writing so my client has the ability to respond to that. And again, the restraints are very specific. It's to prevent her from stating things and interfering with my client's ability as a special eds school teacher. And so that's pretty specific. This isn't a full restraining order relative to anything else. And again, I don't think that it's appropriate to just say we're going to grant leeway, and offers of proof can be made and information can be provided that my client would normally have the opportunity to reply to. And I don't think that that's appropriate. I'm happy to move it just 1 week if that is easier for counsel.
Well, counsel's aware that next week is judicial conference, so that's not available. Second, I would ask the court to review in re marriage of Suggs, which is 152 Washington 2nd 74. It's a 2004 case. And I would argue that this is an effort at an unconstitutional restraint on free speech in alignment with that case. There was an anti-harassment order issued in that case. The Supreme Court overturned the Court of Appeals, which had upheld the anti-harassment order prohibiting the respondent from making false statements about the opposing party, the protected person in that case. The Supreme Court overturned the Court of Appeals and determined that that was a pre-restraint on free speech, that individuals are allowed to make statements relative to facts of cases. And if we got into the actual arguments, looking at Mr. Brown's declaration, he's relying on hearsay from an unnamed source. We're obviously in a public forum. This is currently being streamed on YouTube. I'm assured that there's more than just my client and Mr. Brown who are involved in the Longview and Kelso school districts as either participants or observers to these types of proceedings. And the suggestion that my client has engaged in behavior without one shred of evidence supporting a precursor on her free speech is totally unfounded and unconstitutional according to that case law.
And then Ms. she can respond and she can provide this stuff in writing, and my client has the ability to respond to this. But to now come on here and to just cite case law and want leeway in statements from her client that have not been put in writing, that counsel now, I guess, is going to make offers of proof on behalf of her client, that's inappropriate. So I'm happy to move everything over 2 weeks if that's what needs to happen, but I don't think that it's appropriate. There's already been a statement made by my client to the court indicating that notice was not provided. The court is fully aware of the law, of statutes, of case law when they signed that order, that temporary order, and knew that counsel was not given notice of it, and they issued the order. The court could have certainly said, I'm not going to issue that temporary order right now. I'm going to set it over for hearing. And the court did not do that. The court made the decision, which it certainly has the right to do when you send that in. They make a decision. Is this something we need to sign today, or is this something that we need to set on a docket? And the court signed it and then set it over. So that was a choice by the judicial officer when they were presented with that motion. And so now it's the choice of either moving this out and continuing it, because I don't think it's appropriate now to just give leeway to counsel on behalf of her client to make offers.
Okay, I'm done. So here's what I'm going to do. I'm not going to extend an order that I think could be unconstitutional. I'll set over the restraining order, but I'm not going to extend the current restraining order. So we'll revisit it at a hearing where the parties are allowed to respond, and we can have a full argument once declarations are filed, but I'm not going to extend an order that it, frankly, on its face appears that it could be unconstitutional. So that's where we're at. So
Give us a date.
2 weeks is closed. The next available date is the 3rd of October. So we can do the restraining order. So I will not extend the temporary.
And I'm out of the state that week. Would the court be willing to do the 10th?
10th is available as far as I know.
Okay.
So we'll do the full hearing on the restraining order on the 10th of October, 2023, 1:00 p.m.
Okay. And I'll get reply documentation filed.
All right. And so then temporary orders. I show that we're already on for that. Hold on a second. 7 months is my note that I made for time child and dad have been apart. Is that accurate? Both parties agree to that amount of time?
Approximately
Okay.
that. Sure.
Okay. And then Miss Day is present, and I'm really glad that she is. And we have, she just was appointed relatively recently. I don't know how far she's gotten in her investigation. I did see a request for a proposed parenting plan filed by Mr. Brown, and essentially a motion for dismissal of the restraining order that was entered by Commissioner Nelson back, I believe, in late June or early May, or late May, early June, excuse me. So we still have those two issues to discuss, correct?
Correct, Your Honor.
Yes, and just so the court is aware, originally this has started as a protection order, and Ms. Day was appointed as the guardian for the child, guardian ad litem for the child in that protection order. So she'd already commenced her investigation, I think, back in February. And then just so the court's aware, counsel and I just received an email from Ms. Day outlining recommendations, and I had just emailed back some questions that I had for her.
And Your Honor, I have not received that. I haven't looked at my email. As you know, I've been on this court docket here, so I don't know what that email says.
You want me to address that, Your Honor?
Sure.
So I just provided an update to the parties to let them know I have been on vacation for August. I have been actively working on this case. I've met with both the parents. I've had an opportunity to observe the child. I've spoken with the child's current provider and the provider who was appointed through the sexual assault grant. I've talked to the daycare providers. I have some more things to do before I'm ready to write a report, but I did have some concerns. In the initial restraining order, the sexual assault protection order, I had recommended supervised visits, and the court had declined to do that. There was an additional report made shortly thereafter. And so where I'm at right now, and after talking with the provider who's currently working with child, it's my recommendation that there be a psychosexual evaluation done, kind of put this matter in with a professional who can really tell us what's going on here. We have a child who's made some allegations. Those allegations have been reported. 2 CPS investigations have occurred. Those were closed unfounded. There was a law enforcement investigation, but no disclosure made at CJAC. So we're really stuck in this holding pattern. And I feel like after talking with the counselor, she indicates some good progress, but she has some concerns about renewing contact at this time. And I think that makes the most sense. If we can file or have a collateralized psychosexual evaluation and have that completed, I think that can answer some questions and bring us to a place where I can feel comfortable writing a report, because I then would have a full picture of what's going on, what's happening here.
What kind of timeline, if you are aware, Ms. Day, do we have to accomplish one of those?
So I talked with Dr. Poppleton, and he's recommended Dr. Lee as somebody who might be available relatively soon. He is in Vancouver at Northwest Family Psych. I've not worked with Dr. Lee very often, so I don't know a lot about him, but I do trust Dr. Poppleton's recommendation. I think that being done, if we can get that scheduled fairly quickly, I think it could be done fairly quickly. My report is due in November. I think if we can get this part of it moving forward, I think that might give us some more information. And also I'll continue to be in touch with counselors.
Ms. McLean, since you've had an opportunity to review the email, is that a good summarization of what issues Ms. Day brought up in that?
Yes, that. And then my questions for her were, one, whether or not she had a provider that she was recommending, and she immediately responded back, as she indicated now, with Dr. Lee. And my other question was whether or not she expected the psychosexual evaluation. So she says actually a psychosexual evaluation with a plethysmograph. And my question was whether or not she was also recommending a sexual history polygraph, as my understanding is that those typically go hand in hand with those types of evaluations. So I would want, at least my request would be that there also be a sexual history polygraph. And then she clarified my other question as far as her email in regards to visitation. I thought that there were two different recommendations, but as I understood her presentation now, both counselor was recommending no contact, and that she's also recommending no contact, and we would agree with those.
So my understanding from Dr. Poppleton is that it does include the full history.
Okay.
I had recommended the plethysmograph. My understanding from Dr. Poppleton is that is something that would be recommended by the provider if it was necessary. So from the testing, that would be something they would recommend if they thought it was necessary. And I'm happy to follow that recommendation. As far as the visitation, I am going to agree with Counselor. She's the one who's working intimately, and she's indicated that's made some good success over the last couple of months, but it's tentative, and she's concerned that initiating contact at this moment could be detrimental. And so that's her recommendation. And I'm going to stick with what she's offered. She's the therapist.
And Your Honor, I would suggest that, first of all, I think it's really interesting that counsel all of a sudden wants to have a polygraph test when she and her client have so adamantly opposed this court even considering any sort of polygraph test at all in any capacity. So when my client wants to submit a polygraph test separately that benefits him, there's an opposition. But now when we want to do a polygraph test regarding a psychosexual evaluation, oh, please, absolutely have this court order it. If this court even is going to consider it, I think it should be based on the further recommendation after an evaluation of the evaluator, whether that is necessary. Also, what's interesting, Your Honor, is that this counselor, every single piece of information from this counselor has come directly from mom. And mom's information with the background history, with all the information, at no point has this counselor at all ever spoken to dad, have any information from dad, and everything is based on that. Even the statements about saying, well, she's doing well, not in dad's care. She has no baseline at all regarding what the child was doing like in dad's care before the allegations were brought up by mom. So she's making these recommendations that this child is doing well by not seeing dad, and all these statements about the relationship between dad and the child when there's zero baseline at all, because no information has ever been provided by dad. None of these individuals have ever seen dad with the child previously. And so now we're going forward saying, well, the counselor is making recommendations that it wouldn't be in her best interest to see dad. She has no information at all regarding dad. The entire base of her information has come from mom. The statements have come from mom. The statements that mom is saying that the child made have come from mom, that the child made to the mom, also to daycare providers that were selected by mom, that are friends with mom, where mom worked for 8 years. Everything revolves around mom.
I guess I'm going to object at this point. This is outside of the scope of any of the statements from the counselor, any of the statements from, quite frankly, even Mr. Brown hasn't testified as to what the counselor is aware of. So, while I understand counsel's making argument, she's arguing facts that are not before the court in sworn declarations or medical records from this child's counselor.
None of the medical records state at all that there's been any communication whatsoever from dad, or that any information has come from dad, or that the counselor has had any viewing or any baseline to start from regarding the relationship between the child and his dad. Quite frankly, she's never even seen the child with dad or had any conversation at all. So for counsel to say, well, the counselor is also recommending that there be no contact, so I agree with that counselor. And so, I mean, how much further is this going to keep going on? We have 2 CPS records unfounded. Every single independent person that does not have a relationship with mom prior, or is not part of the tribal clinic, where also the grandmother works and is the receptionist there, have said unfounded. And my understanding is the guardian ad litem has also heard the voicemail from the police investigator saying they're not pursuing this. So we disagree that there should even be a psychosexual evaluation. We have no information at all regarding even a supervised visitation between the child and dad. Nothing at all. No involvement at all. No, nothing. To now go ahead and just say we want a psychosexual evaluation when every single independent person who is trained to evaluate allegations of sexual abuse has said unfounded, no information. There's been a CJAC investigation. There's been a sexual assault kit done. Every single thing possible that mom says that she's done by the book have all come back that none of this is valid. None of these allegations support anything that mom is saying. And now we want to do a psychosexual evaluation? At some point, it needs to stop.
So, Ms. Poplawski, what's your position on just the recommendation of the child's counselor to not have contact currently? I'm assuming you would be all for it if the roles were reversed. You'd want to listen in the best interest of the child.
Actually, I think the best interest of the child is when that counselor has the most amount of information and when that counselor is independent. This counselor was chosen by mom. This counselor is part of the clinic, the tribal clinic, where the mother of the opposing party, where the grandmother works at, all information was provided just by mom. honestly, I'd ask for an independent counselor, someone to review all of this, to talk with both parties and the child. This child is so far into this counselor where the entire baseline that was provided to this counselor was there's a restraining order, there's disclosure of sexual abuse, dad's a drug addict, an alcoholic, a porn addict, and all of this prior information. That was what the counselor then starts the counseling of the child on a basis of, without ever getting any independent information. And so now we have this counselor saying, she's doing well, shouldn't be involved with dad. Not even one single conversation with dad, not even one shred of independent information. Everything.
Okay, I think I get your point. Miss Day?
Yes, Your Honor. Do you want me to respond to that, or do you have a question?
Well, a little bit of both. I know, is this counselor associated with mom or mom's job, or is this the counselor that was referred based on the CJAC interview? I guess it appears to me that there was some counseling extended by way of the CJAC process. And I don't know if there's two different counselors or.
So there were two different counselors. So this counselor, Celia Delaney, is the initial counselor that was sought due to some of the behavioral concerns. And that happened at the same time. After the CJAC interview was referred to see another provider through the sexual assault grant. And that provider made another report after disclosure. I'm still seeing that provider because that's a limited time. It continues to see this provider through the tribe. She is not somebody that I would say is associated with mom in particular. Yes, mom did have input in the initial, as any parent does when they get counseling set up for any child, no matter their age, almost always. I don't have any objection if there was something that the court wanted to have somebody independent talk to both mom, dad, and the child. I don't have any objection to that. My understanding from the recommendation from Ms. Delaney, the current counselor, is based on presented initially and how it's doing now and things that were said in session. And that was the sum of that. I don't feel like it's appropriate for me to go into further of that until I've written my report and follow up on that. But that's based on her interaction over the last 7 months.
And I would just like to correct one thing, still seeing Ms. Anderson. She has another appointment scheduled for tomorrow. And I believe that those are going to continue based on her recommendations, but I think they're going to transition from paid under the grant to private pay.
And so that would be new information because my last contact with Ms. Anderson is they had stopped contact in June. So that would be something that there had been no contact then for June, July, and August, and she must be restarting then.
Yeah, my understanding is that there's an appointment tomorrow.
Okay.
And Ms. Anderson is the counselor that was referred through the CJAC process.
Correct.
Yes.
Correct.
Okay. Okay. Have either of these counselors made any attempts to speak with dad?
Not to my knowledge, that's not normally done.
There's also no counselor that has even done a virtual visit with dad to view the child's responses. Absolutely nothing. There is zero baseline to make decisions regarding this relationship.
Well, other than and this came out at the time of the testimony from the protection order, where it was disclosed by I'm forgetting her role. Basically, she's the director, of Faith Family Daycare of sexualized behavior that had started within the school setting, daycare setting in November or so, that had been noted by the teacher. That involved other children, that they also, Ms. Charlotte also testified about the dramatic manner in which would come back from visits with Mr. Brown, extremely upset, crying, histrionic. I mean, just something that was really bad that was happening to her, and that was her reaction. And that was the basis for Commissioner Carmi entering the protection order. Since that time, my understanding is that behavior has more normalized now that we have had no contact with dad and no exposure to whatever has happened. I don't think that it would be appropriate to expose a potential minor sexual victim to the potential predator until we have a clear understanding of what's happened here. This child should be treated as a victim at this juncture, given her disclosures to two independent counselors. It wasn't my client who made those disclosures. It was the child who made those disclosures independently within closed sessions with these two different counselors. And both of those two counselors made independent mandatory reports to CPS. So at this juncture, The criminal case is open but inactive. They're waiting for her to go through and finalize those sexual treatment therapies under the grant, and to determine if she's able to provide that additional information outside of counseling sessions.
And Your Honor, these disclosures were only made either to mom or with mom present. Then when the—
Your Honor, I'd object. That's outside of the scope of any factual documentation. Again, when you go back and look at the counseling records, it suggests otherwise.
And then whenever the professionals were involved, again, that are trained to deal specifically with this, they made not once, but twice findings of unfounded. My client is a teacher for special needs. I can guarantee you that if the police had any idea that this was something that they felt had an appropriate basis to pursue, my client would have been charged, or this investigation would have been going forward, and it's not. The guardian ad litem listened to the voicemail that said that there is no probable cause to move this forward. I don't know how many more times it needs to be unfounded, but there's an unfounded report, and then what happens? Now all of a sudden there's a new allegation being made after my client hasn't even seen this child for months because mom doesn't like that finding. So now there's up the ante. And keep in mind, these coincide when mom doesn't like the girlfriend and the girlfriend moves in. The prior allegations,
What accusation has been made recently?
I'm talking about the second accusation after the first CPS investigation was closed, unfounded. Then
Everything I read indicates that the child made those to a counselor, and the counselor is a mandatory reporter and reported them, not that mom made the report. So if you can show me where I'm wrong, please point that out.
My understanding is that mom reported it, then took the child to the counselor where mom was there and had the child disclose that. Now, when the investigations were made, there was no finding that there was any of these sort of reports by CPS. And my understanding, and unless I'm seeing something wrong relative to the daycare records, so apparently there was all sorts of issues going on, but there were never any reports made by the daycare, who are also mandatory reporters, until mom now makes allegations, whose mom's friends with the daycare workers. And now all of a sudden there's reports being made by the daycare workers only after mom makes the allegations. I mean, this is all centered around mom making these allegations, coinciding with things she doesn't like that dad wants or that dad's doing. There were no issues at all previously. Then all of a sudden, dad's girlfriend moves in. Now all of a sudden, dad's a sexual abuser. Now all of a sudden, dad is an alcoholic. Dad is a drug addict again. 3 years, she was able to ask dad to do a UA, but she had to pay for it. Never did it. Now all of a sudden, raising the issues again. He's a drug addict and alcoholic. How much more stuff can we keep throwing at dad? Dad's a school teacher. Dad's special needs. There's absolutely no complaint ever made. There's nothing in his history. He went through a full investigation. He tells you again with the school, they find nothing. It's mom who starts all of this, mom who then gets an order that she has the decision making to again get a counselor, and then she's the only one providing the information. Again, the baseline from with which these statements are being made, even by the counselor, absolutely zero communication from dad, absolutely zero information at all. And now we want to put dad through a psychosexual evaluation. We have the most trained individuals, CPS, the CJAC, sexual assaulting, and let's keep doing this. Let's keep making more and more allegations. Let's keep putting him through the ringer with us.
So with all due respect to the arguments on CPS, while they do a diligent job, they are certainly overworked, and their protocol is that once the child is placed in a safe environment and they're aware of that, and the recommendation was that mom seek a protection order, which she did, and that protection order is in place, then that is the basis for them to enter an unfounded filing.
Where is this information?
I'm sorry, am I going to be allowed to make my argument?
It's not in the file. That information is not in the file. There is no letter or no statement.
Well, Your Honor, I would refer.
I understand the objection, Ms. Poplawski, and I don't disagree with it, but I'm going to let Ms. McLean continue.
Even his own declaration says that. In any event, we have, while those are unfounded, their level of investigation is different compared to a criminal investigation. And obviously, when we're talking about a minor child who is potentially and arguably the victim of sexual contact by a parent, that child needs to be protected. And that's what we're asking the court to do. Counsel, again, made unfounded, unsworn arguments about my client's mother's relationship to the tribe. My client is not the receptionist at the tribe. My client works in billing. She's not even in the same building as the counselor. My client's mother has not been involved in that counseling. My client has facilitated the child to and from counseling. She has provided initial feedback to the counselors as they have requested. The counselors have met independently with the child and have made those mandatory disclosures. The information that we provided about Mr. Brown's historical marijuana use, sexual addictions, and the like were to counter his declaration where he said that he's an upstanding father, and to refer the court back to the prior case filings where there were reservations on 191 findings against him and a court order that required him to obtain a clean UA before he could have specific visitation. And that notably that clean UA wasn't provided for more than 30 days. And that was so that Mr. Brown could allow his system to clean out because he needed to have a clean UA. That's the basis for raising those, that information to the court, is to contest Mr. Brown's credibility before the court. So we're asking again that the court continue to protect this child, allow the investigations to be completed. Now that CPS has filed or made those findings of unfounded, it's my understanding now that their case would be open for Ms. Day to request those records so she can go in and look at what those records say. My understanding, and Ms. Day can correct me if I'm wrong, that while the case is pending with CPS, those case filings are not available to her. So I think that that's also another factor of information that would be helpful for her to see and to verify, contrary to what counsel's arguing, that again, even though you have the statements from the counselors in their notes that they were the ones that reported this as mandatory reporters to CPS, those are directly in their case notes that we filed under seal. Obviously, Ms. Day would be able to verify that by having CPS records as well.
Your Honor, my understanding is Ms. Day has spoken to CPS and she could provide this information to the court. And she's also heard the voicemail from the police saying they're not pursuing this. And relative to the UAs, the court order said to provide it by August 14th. My client did that. My understanding is he provided 2. And for 3 years, mom had the ability to request a UA of my client so long as she paid for it. And not one single time did she do that. And so I would ask this court then to ask Ms. Day if she listened to that voice message from the police investigator and also if she already spoke with CPS.
Ms. Poplawski, you probably don't know anything about me or my history. I was a prosecuting attorney in this county for an extended period of time. I know what happens in a CJAC. I know the terminology about around these cases. I cannot sit here and say it's over and done with at this point because I don't know, especially if she's in counseling with CJAC. They may attempt to do another interview at some point based on what occurs in that. So I'm not trying to be disparaging of anything, but I just wanted to give you a little bit of my background information that I have some additional knowledge about the process, some of the terminology that's used, especially in these types of cases. There was a pretty significant period of time where I exclusively prosecuted those types of cases. So I'm very aware of the process. I'm not suggesting that Mr. Brown did anything wrong at this point in time. I have no idea whatsoever, but I'm also a little reticent to think it's, over and done with. There's nothing else happening. Here's what I'd like to have happen. We're set for October 10th. We're going to come back on the restraining order. I understand that there's a lot of different parties, and I understand that Mr. Brown just feels somewhat isolated for everything that's going on in this case. And I understand that. I also, I'm sure he understands how significant and serious these allegations are. He's dealing with those on a different level than the other party and the child are dealing with them. And I can see from all angles. After I was a prosecutor, I was a defense attorney. So I understand kind of the fallout from those types of allegations. I do think that there's a few different ways we can do this. I do think that there should be an independent look at what's going on here. We do have 2 different counselors for the child. And one of them is Patricia Anderson, correct? And that's the one that was referred through CJAC. Patricia Anderson is in the same, I believe, and I know Miss McLean can correct me if I'm wrong because we just had a family law brown bag about this with Miss Lovely and, Olivia Lovely and Charlotte Rosen. Are they all under the same?
Not Miss Lovely. It's,
okay.
Ms. Rosen and Ms.
Anderson are under the same.
Ms. Anderson and there's another, and she does supervise visits, and I can't remember her name. She used to be with DOC, I think.
Barbara.
Yeah, Barbara Brandhorst.
Okay, are willing to do reunification evaluations, which is essentially an independent look, dink, and child. I think that's appropriate. I think dad should get an opportunity to talk to somebody, weigh into what's on his side, and maybe we can get a fresh perspective from a counselor that is able to have a conversation with dad and get some insight from dad and a feeling for dad. If that needs to happen by way of since we are on 7 months at this point where there's been no contact, that needs to happen by way of the order of a reunification evaluation to get it. And my understanding is those can happen rather quickly. Then that's what I'd like to do. Is Dad located here locally, or is he in Vancouver?
Yes, Your Honor.
Local. Okay. So that would be at least the quickest way for all parties to be able to just have a kind of an independent person to kind of assess the situation. I also want that person to be able to speak with the child's counselor. And do you think that we could get some input from that person, Ms. Day, by the 10th of October, assuming all parties get that's a month from now, get something set up as soon
I
as
think
they
that's pretty
possibly
likely. I can reach out to the parties. Do we want to have agreement on who that person could be, or just who's first available?
Well, I'm assuming not Miss Anderson.
Right.
Because she would, so
Sure.
anybody besides her, I would say first available.
Okay, I will reach out to Charlotte Rosen and Allison Long. I would think that Allison probably has first available, but I'll check with both of them and keep everybody in the loop on that.
So, so basically what I'd like to do, and I know that our final GAL report is mid-November, is that correct? So is kind of, and I hear the request for a psychosexual evaluation, and I understand the request and frankly may order that, but I would like to have this a conversation where a counselor speaks to all parties first. So if we can get that done as soon as possible and have it on for the 10th, if Ms. Day, if you're able to put anything in writing, even if it's an email to all the parties, so there's some notice of kind of what to expect, that'd be great. Or if the counselor wants to provide something to all the parties, so there's a heads up, that'd be great. I don't know. I know that's generally pretty quick turnaround time for a counselor, but that gives us, that's 4 full weeks from today.
And then how are we handling costs? And I don't know what those costs are.
I don't know that the initial, my understanding was the initial evaluation would be free of cost. If there was follow-up treatment, then it would be through the same individual, and then that's when the cost would incur. So if there are costs, then I would want to review that on the 10th so that we can make a determination. And I'm happy to make that determination about who does what, who pays what on the 10th. So unfortunately, after all of this, I think there's a lot of concerns here on both sides of the board. And I want to afford Dad an opportunity to have a conversation with somebody and that individual to kind of just touch base with all the parties and get some feedback at the very least to Miss Day. And so I'm going to set pretty much the remainder of the issues to the 10th of October. So that'll be the request for the release of the immediate restraining order to look at the parenting plan and for the request for a psychosexual evaluation along with the restraining order.
And Your Honor, if I can, I just want to make sure that Ms. Day did actually speak with CPS and listen to that recording. So she has that information relative to when we come back on the 10th, if she can just answer that she did, or if there's something we need to do to make sure that she gets that recording or that she's able to talk with CPS before the 10th.
I have done both of those things. I have heard that recording. I've talked with the detective and I've talked with Ms. Sanders. And I've also sent for the full record now that CPS has issued their unfounded letter so that I can see everybody that was contacted and interviewed, because I know there's some confusion about who was contacted and who wasn't contacted.
Okay, thanks.
Okay. So Ms. Day, that puts a fair amount of work on your lap for the next month. Ms. Teeters and Mr. Brown should work to get those and I'm assuming it sounds like Ms. Day is willing to kind of help coordinate and figure out who the quickest counselor would be available. So just make sure to make yourself available to meet with those counselors as quickly as possible. And hopefully we can get information before the 10th so parties can weigh in, but no later than the 10th if at all possible. And to be very frank, I'm willing to hear that information on the 10th, even if the parties haven't had a chance to respond in writing. Just given the posture of the case, I think that's prudent at this point.
Okay.
I sent an email to both the providers, and as soon as I hear from who's most available, I will contact both the attorneys and help to move that forward, and then help coordinate whatever needs to be coordinated so they can meet with the parents. And
okay. And then just so council's aware, the guardian ad litem order has my client's current address, and that's not changed. So just so I'm sure, so the court is not reissuing a temporary restraining order against my client.
No.
We're going to argue that. Okay,
I'll
thank
adopt
you.
that if it's agreed.
All right.
So then I know
Thank
that
you.
may
Good
be the
luck.
only thing, but hey, it's
Thank you.
something. I'll take it.
I'm going to do
Today's
what I
been a day.
traditionally do not do. And if you have questions or anything you need to know, please fire away. I'm going to really, and I promise, try to keep this short. You've got everything by the pleadings. You know what the issues are. If there's anything specifically you want me to focus on, I'm happy to do so.
Here's I'm going to just be upfront with the parties as well that today's been a long day. This is I did review everything in this case. Here's where I have some concerns. There's I think I made a previous finding earlier this year that Miss Honey has been less than forthcoming with the court, and there's some concern there. The request for a restraining order. This is kind of just where I'm at right now with based on what I've reviewed. I don't know that I'm willing to completely restrain mom from visitation. I think visitation should continue, but I do think that that mom should not have any romantic partners around the child during any of her visitation time unless it's been prior there's been prior approval issued by the court. So that's kind of where I was looking. Mom claims that isn't an issue, but very consistently child has indicated otherwise. That was an issue earlier this year with a different individual from last fall. I know Ms. Rush hasn't been on this case for that entire time, but when I see the same type of issue more than once, it is a little bit concerning. I'm not suggesting mom cannot have a romantic partner, but that romantic partner shouldn't be in the home, spending the night at the home while the child's visiting, unless it's an established relationship that's been brought to the court. So that's kind of where I landed, and I don't know if anybody wants to weigh in on that, or if there's any contrary arguments or additional information that I wasn't able to review. And for the record, I did review everything that's been filed in the month of August moving forward. So, and I think that covered pretty much everything. And that includes the most recent declaration that was a supplemental declaration that was filed on the 8th.
So a couple just arms from that. The first would be reappointing Miss Height. I don't see any reason to not do that. I think that's a simple one. This is a case that's been wrought with conflict and from the beginning. Obviously, having another set of eyes on that seems appropriate. I would just ask that she be reappointed according to the existing and prior GAL order. That's first and foremost. Second of all, you saw, as it relates to the parenting plan, some discussion and issues raised by my client about the child missing out on extracurricular activities, again, over mom's time. Mom rarely takes the child to those. I don't know if that is a passive aggressive type refusal just because it wasn't something that she instituted, but nonetheless, we would like an order that mom is to take the child to softball games, soccer games. And I know I made this argument and pitch earlier in the day. Again, the same applies here. I think it's appropriate to do that. Michaela's doing very well. She likes interacting with her friends. She's successful in sports. It's a source of pride for her. We would ask that be ordered, that Miss Honey actually take the child to the events over her time and not essentially blow those off. So we would ask that be contained in the order as well.
And just as a point of clarification, as far as Miss Height goes, what specifically would you be wanting her to look into if I were to reappoint her?
I don't think we're going to have a trial date for this anytime soon. I do think that maintaining some kind of oversight from a GAL perspective is probably important, especially on this case, given the amount of strife and conflict that we've had over the past, specifically a year or so. She was appointed under the old form of the GAL order that states as soon as that final report is issued, she's released. We've kind of gone away from that a little bit in time. If the court wants that input, I certainly think it would be appropriate to do that. If not, we'll kind of piecemeal it together on an as needed basis.
Ms. Rush, you want to reply to any of it? I guess. I'm sorry. I won't interrupt.
No, that's okay. So there's three main topics that I see here. The first is the restraining order and the alleged significant other. The second is the reappointment of a GAL, and the third is extracurricular activities. So I'll kind of touch on those. Starting with extracurricular activities. I think that Mr. Mitchell and his attorney know that my client's not blowing these activities off. She stated multiple times in declarations, including for this hearing, that she doesn't take that decision lightly. But given that she went from having primary custody of Michaela to 4 nights per month, those nights are aligned with her other son. And so she's trying to make sure that the siblings have interaction. And sometimes driving from her house to Rainier is just not possible to do that. And so given the limited time that she has with Michaela right now, she's not blowing it off. She's not being passive aggressive. She's really trying to maximize her time and also Tristan, the older brother's time with Michaela. If the court wants to make an order, I'll defer to the court on that. Again, going from having her full time to having Michaela 2 weekends per month, my client's doing the best she can to make sure there's quality interaction and quality time, but she does support her extracurriculars. She always has, her entire life. With regard to the GAL, and this is not with all due respect to Ms. Height, we as lawyers, we do have to advocate for our clients. When I came on the case, we did start having a second opinion done to review the GAL report. And we're not purporting to state that there was a second GAL evaluation. This is an expert that we hired to review whether the GAL report was done procedurally and substantively correct. And I think that our problem is, when my client is putting down, and when we have an expert who's been doing GAL work for 13 years who reviewed the report, and she's not saying, Ms. Height did this wrong or did this right, but she did have some criticisms. And I think the one specifically that my client has a problem with, that I wasn't her attorney when this came before Your Honor on a hearing, but the GAL expert who reviewed this stated that basically there's so much information from dad and nothing from mom contained in the report and the file to really substantiate some of the recommendations that were made and to be useful for the court. And so I won't go through some of the quotes, that were in the second opinion, but, she basically had, I think it was 6 collaterals for dad, 2 for mom. There's just a lot of things that you see in there that my client is claiming purports to be a bias to her. So my problem with that is that if we get down the road and we're at trial or something, my client's gonna have the same concern, likely, unless something turns around. And so rather than set us up for failure, if we're going to appoint somebody to look into this pending trial, we don't have a problem with that if he wants to pay for a second GAL. It just needs to be somebody else. Because I think when the court's hearing that there's this concern about the GAL's process, again, with all due respect to Ms. Height, my client has that concern based on her own opinion and the second opinion. I don't think we should reappoint someone when we know that there's that concern. The third issue, the restraining order, I'm glad to hear that the court's not inclined to grant that. I understand why the court ordered it on an ex parte basis. Unfortunately, we were prepared to respond and to file a declaration and all that, but I know that that's not how ex parte works up there. So my client didn't have an opportunity to be heard. The minute we heard about this concern, whether it was vetted or not, we reached out to Mr. Zandy and said, great, let's enter an order saying this guy has no contact with Michaela. And then they still proceeded with filing the motion. So in my view, they went for the most restrictive resolution versus the least. And I think that when you're completely cutting a parent off from a child, we need to look for the least restrictive resolution that solves the problem. That could have been done by an order saying this child's not to be around Mr. Although my client disputes she has been, but there could have been an order that said that. I think just on a closing note, and my client has put this in her declarations, and I know Your Honor's familiar with this case. My client has Mr. Mitchell, who's her ex. She also has an ex-husband who is very involved in the situation with his spouse. Those are the 2 cases that have written declarations. I think the concern that I have and that my client shares is these people, and I say Mr. Mitchell, kind of his group of people that are supporting him, they've had a GAL report in their favor for almost a year now, yet they're still following my client. They're still surveilling her. They're taking pictures of her and purporting, undated pictures and saying, look at this car parked outside her house. So to me, it's a little creepy, but I think that's borderline on abusive conflict. And so I don't know why these people a year later are still tracking her and doing things like that, but that is concerning to me because they're kind of looking to create problems. So my client has not seen Michaela now in a couple of weeks. She normally gets every other weekend, so we would ask for some makeup time. Perhaps she should just get the next or all the weekends in September or something like that. She only gets Friday to Sunday, and that the restraining order be dismissed. Like Mr. Zandy said, if you have any other questions, I'm happy to answer those.
All right, thank you. Mr. Zandy, any response?
Yes, and again, this comes down to one party's ability to tell the truth. I think if we look at the report filed by Ms. Height some time ago, and there was in the court's concerns about being candid and bringing the information forward, that has always been front and center for Ms. Honey. The information you get is rarely borne out by the facts. Again, if we look at the information provided by Ms. Height, that is largely substantiated from Dr. Maher in the report he filed related to her mental health. And again, the information that she provided him was scrutinized, and some of the elevated test results were again looked at. And what's kind of a common theme, again, it's how she presents herself and what she does with the information, wanting to be seen in the light most favorable to her. And that's just not borne out by the facts. Again, I think that can be no further illustrated than her saying, well, I know this guy is dangerous to children. I know he has prior domestic violence convictions. I know that he just got convicted in May in Washington County, Oregon, of soliciting underage girls online. But we were only loosely dating. The information that's provided to you shows that he was at her house. It shows that his tongue is halfway down her mouth in the picture, where they're outside of a parking lot somewhere where she's supposed to be at work. Again, not borne out by the information in front of you. That is all problematic. Now, the fact that she says, well, we're no longer dating, but they're seeing after the fact, after this motion's been made, after she comes to realize that he's been convicted of sex crimes against children, potentially riding around in Castle Rock, in the driver's seat of his vehicle. Again, these are all problematic, and it gets down to one party's ability to tell the truth. And that has been, unfortunately, an issue with Miss Honey from the very onset of this litigation, and hasn't gone away. So as far as raising some concern about people taking her picture and following her, I don't think that's what's happening. I think she willingly puts herself in these positions where that's what's seen and that's what's readily observed by people. So that kind of is what it is. We look at the most restrictive versus the least restrictive manner, although the court has entered its order, and certainly I hope Ms. Honey takes that to heart and follows that. My client and I have very little confidence that she will. just based on the history. She says Mr. Anderson is no longer around. She states that again after this loosely dating relationship. Now that he's not no longer around, we have very little confidence she's actually going to maintain that. And I think going back to the timeline of this, we were in court back in February. She goes in to get her mental health evaluation with Dr. Maherd on March 7th. He issues a full report on April 14th. She's dating, loosely or not, Mr. Anderson at this point in time, and fails to disclose that to the provider. Again, that reeks of dishonesty and deception, and that is unfortunately what we have moving forward in this case, and that is what it is. Finally, as it relates to one issue that we didn't clarify, I think we're agreed on the $665 a month. That's fine. We just need a start date for that. My child's been in my client's care again since March. We're asking for retroactive set support amount, or alternatively reserve on that and make support effective August 1st, which would be appropriate as well.
You want to address that last part, Ms. Rush?
Sure, Your Honor. I don't think it's fair for somebody to sit on a child support request for a number of months and then all of a sudden it'd be retroactive and my client would have to come up with a bunch of money. I think that they filed it in August. I think making a start date September would be fine. And then if Your Honor wants to reserve on retroactive, that would be just fine as well. I have other comments, but I don't think they are germane to what your decision is going to be. So I'll hold on those.
All right. I'll make child support the 665 August 1st. Then reserve on anything else if that's something that's raised at trial. It's raised at trial. Hold on, my pen just ran out. I indicated I wasn't going to enter the restraining order as listed. Visitation will start back up again. There will be just that prohibition that I outlined, that no romantic partners around the child, staying over in the home, meeting up at any place with a romantic partner when the child is with mom for visitation. So that's just kind of a new caveat, unless that partner has been approved by the court. Extracurricular activities, I understand the difficulty, and that's kind of coinciding with another child in the home. Unless there's some set out travel plans that are relayed to dad in advance, I'm going to say a minimum of 2 weeks in advance. The child needs to be at their extracurricular activities. Those are important. It's a commitment that's made, and that shouldn't suffer because of who they're currently residing with. So,
Your Honor, can I ask a quick clarifying question on that? Can we make it so that those are either historical or agreed upon, just so we don't have an issue where somebody all of a sudden gets enrolled in a bunch of new stuff?
Mr. Sandy?
Well, this child's always been active in that. I mean, the issues come down to now she's living in Rainier, so she's in the Rainier sports. Prior, it was Castle Rock. So since that change has been made, it's still been the softball. I think still basketball is still a thing. I don't know about fall sports, but traditionally this child's been engaged in the same activities. I'm happy to provide notice to Ms. Rush of those, but I don't anticipate anybody's going to enroll this child in a bunch of activities for a child this age. I think they've been pretty consistent over time.
Okay. And Your Honor, my client just texted me and I forgot to bring this up. One of the other reasons that sometimes they miss Michaela's activities is Tristan has out of town tournaments. So that's time. I just want to bring that up for the record. I know Your Honor's going with this, but it's difficult to be in two places at once when you have that. So,
well, and if that becomes a consistent problem, my hope would be, and this may be a stretch, but my hope would be that Miss Honey and Mr. Mitchell can work together to ensure. I mean, if Miss Honey needs to drop a child off at 7th Avenue for a soccer game and then come and pick them up, 3 hours later after she runs to Vancouver for a different event for another child. I don't know if the parties are in a position where they can work together in that way, but that would be the hope, that I wouldn't just be, okay, well, it's the other child's in more advanced sports, so those trump the other child's activities. So I'd hope there'd be some room to maneuver there. If there are, if she knows in advance that there's a tournament in Eugene, the third week of October, and that's the same weekend, and other child has events up here, maybe they can communicate and do a switcheroo. I understand wanting the kids to be able to have time together. That may not always work. So
yeah, it's just she has a shared schedule with her older son, and I mean these tournaments are in Vegas. I mean, so that's an example. They're going to Vegas for his tournament in October. So my client's on, so she's heard your ruling. I guess the one thing we just would request that dad be required, if there is an activity or extracurricular, that he give her the schedule, all the practices, everything like that, as soon as he has them, because I think that
that's fine. I'll include that in the order. That's
okay.
great.
I think that's more.
Yeah, I think that's fine, and I'm happy to include that. I just say that a lot of these weekends, Tristan's not around at all, and the child's left in daycare. So that's kind of again, a resounding theme. I don't want to go down that path. We've got the ruling, but again, just to clarify that.
If there's no conflict issues, then child should be at their events.
Okay.
Right.
And if there is a known conflict and they can't work it out, I mean, all these schedules probably should be shared as far in advance as possible. There's no harm in sharing that and trying to work this out. And then that leaves us with the GAL issue. Ms. Height, you're here. I don't know if you reviewed the motion and the response. I don't remember the name of the individual that the supplemental kind of information was provided by. I want to say it started with a Y.
Oh, Lisa Yenny. Sorry, Your Honor.
Yes. Okay. I don't know if you've reviewed any of that. Thank you. Ms. Height, if you feel it's that you
I have not reviewed that, Your Honor.
Okay. Ms. Rush was not the attorney of record when Ms. Height was appointed. I don't have an objection to appointing another guardian ad litem or appointing a guardian ad litem. And I don't have a problem with that being a new individual. Obviously there's a delay there. Ms. Height would be able to kind of step in and kind of reevaluate based on, I mean, she's been out of the case for over 9 months now. So there's new information, but out of Ms. Wade, could you give us the next 3 names on the list?
The next 3 names are Heather Kale, Amy Turnbull, and Ann Height.
I just don't want to start from scratch with another. There is 3 full binders. This is the 4th of pleadings and a lot of catch up to do.
And I understand.
I think it makes the most amount of sense just to keep Miss Height, but that's my opinion.
Your Honor, I understand where he's coming from, and I probably would be making the same argument if I was on the other side of this, but this is a modification case that basically on temporary orders switched custody. So I mean, at trial in this case, it's going to be a big deal. So from my client's perspective, given the concerns that we have about Ms. Height's report, we would like someone else appointed.
And I understand, Mr. Zandy, and I'm willing to do that. I don't, I hold Ms. Height to, in very high regard. I think she does an amazing job. She's always on time. And I feel her reports are thorough. But if there's a party that feels slighted and, and frankly, we're 9.5 months down the road from the last interaction, it may cause a delay, but I'm going to select somebody new. So I guess any strikes, first one is Heather Kale from either party.
Well, not because I have anything against Miss Kale. I do not. I think she's going to be a good one too. I would strike Miss Kale. Yeah, I'll strike Miss Kale.
All right. Any strikes, Ms. Rush?
Well, the obvious one would be Ms. Height. Like, again, I apologize because I do have a very high respect for her work as well. But like I said, we have to advocate for our clients. So
Okay.
Who does that leave?
That's Amy Turnbull.
Okay, that would be fine.
So I'll appoint Amy Turnbull. I am going to proportional pay at this point. And then if there's arguments on financial issues, we can deal with that later. But at this point, I'll say proportional pay by each party. And then
And my guess is we're not asking Miss Turnbull to reinvent the wheel. We're just looking for her to bridge that 9-month gap since January, since Miss Height's last report was issued in January.
Correct.
Okay.
And obviously I'd want her to look at some of the concerns that were brought in, obviously this month and end of August, and some of the concerns that were raised in the spring. But yes, since January. Yes, on both sides. And then Mr. Zandy, you're going to do that order.
Sure.
Because you're really good at doing orders. Thank you. And let's
I'm not, but I appreciate the
have
sentiments.
we'll have an interim. Well, we can have a GAL review. We can either do the 3rd or the 10th.
And do a presentation at the same time.
That's the 3rd is the next available Tuesday. So
I can do the 3rd. I cannot do the 10th, but I can do the 3rd.
Okay. So let's do the preliminary GAL review, October 3rd, 2023, 1:00. That can also be presentation.
And then, Your Honor, is Your Honor ordering any makeup visits for my client, given that she's not had any visitation since the order was issued?
Well, I just suggest she didn't have the visits due to her own choosing and choices. And again, I think that's kind of inappropriate. That'd probably be something we best addressed at the time of trial.
I'm not going to order any makeup visitation at this point.
Okay.
Do we want to set a final review? Does the 16th of January, 2024 at 1 p.m. work? An A in school, so
That's fine.
well, it wasn't
That's
to
fine.
my
Can you double
benefit.
check
I
before I say
apologize.
something?
All right,
So
we're here for review of a GAL report.
Yes. So the GAL has emailed both Ms. McLean and I that she's still working to finalize her report. I find that to be reasonable. She's waiting on drug testing that just came in yesterday, and potentially some additional information based on arguments today. And she asked for additional time. I was fine with that. I think Ms. McLean was also on board with that. She didn't believe she needed a whole lot of additional time. I don't know that I need a review to ensure compliance, essentially to ensure that she issues her report. If the court wants to set one, I would just ask that we set it towards the end of October, within lines of Ms. McLean's availability in mind, which I'm not sure where the confluence of those things comes in October.
So we had proposed that Ms. Kale's report be submitted to the parties no later than October 13, which I think she indicated was agreeable to her calendar, but she can let us know otherwise. And then on my calendar, I'd looked at setting the final review hearing for October 24, which I think would still be appropriate for the court to consider if you are going to adopt any interim report or any interim recommendations pending maybe setting it out for additional hearing and the like.
I'm fine with it.
And of course, parties can always agree to strike that if we want to submit full declarations and the like to the court.
Does that October 13 date work for you, Ms. Kale?
Yeah, absolutely. In fact, the two things that I was waiting on, which were the drug test results that we just got in, I believe came in yesterday, as well as I wanted the opportunity to observe a visit with Mr. Wishart, which I was actually able to do this weekend. So this report really, I'll have this report done probably within the week and filed. And so whenever we're available for these attorneys to be there, I'm ready to roll. There were just a couple of pieces I wanted in place first before we made some final recommendations.
Does that change the suggested timeline of anybody? I mean, do you want to bump those dates up? Or I know that Ms. McLean, you indicated you were going to be gone some first part of October, and I know Ms. Baldwin is as well.
I'm gone the first week of October, and then I'm in a 2-day trial. I don't know when that's going to fall, the third week of October. So that's why I had suggested October 24.
That the 24th is sort of my first availability for dockets.
Okay.
Well, then I will adopt the report due date. We'll just make it noon on the 13th of October, and then a review Tuesday, the 24th, 1 p.m.
Okay.
Very good. So that takes us to our review. The court should have, I believe Ms. McLean and her staff sent around the hair follicle tests as well as the UAs that have come in. And we were set to review visitation as well as what the result of that, of the hair follicle was. Hair follicle at this point shows that Mr. Wishart is clean from cocaine, but not clean from alcohol. And that continues our concerns. It's not uncommon where we have somebody with an issue with substance use disorder sort of have multiple issues, and then they can sort of get clean off of one substance, but not off of another. And we do see that. And at this point, we have persistent substance abuse over a fairly lengthy period of time that this case has been pending. In the materials that they filed within the last week or so, they also included an updated substance disorder evaluation from Kaiser that is dated July 25th, finding that he has a moderate risk of alcohol. But it's key to also understand that that is before this latest round of testing and evaluations. And there's no indication that that evaluation considered any collateral input. And there's no indication that that evaluation considered the awakenings evaluation that was done back in June. So essentially, it's just a cold evaluation without any collateral input. And it still finds that he is a moderate risk. So again, for alcohol. And interestingly, and again, that's not considering the most recent hair follicle that finds he's still using alcohol. That latest substance disorder evaluation says he needs treatment twice a week for 12 weeks. Then they filed some additional progress reports talking about his treatment. And those are actually quite interesting. When you look at them, the report date of that saying, essentially the compliance report date is dated September 1st. And it says these are the days he's attended. So essentially has this evaluation sort of week 1, and then you start seeing him attending groups week 2. And what it shows is the very first week that he started attending these groups. He's supposed to, again, twice a week. You see the very first week, he only attends 1. So arguably partial compliance. The next 2 weeks, so this is the week of August 7th. So he attends two groups there. So compliance. The following week, August 15th, 2 groups there, compliance. But the next 2 weeks, which is August 21st and the week of August 28th, no compliance. He didn't attend any groups those weeks. And we know that because the letter is issued September 1. So we know he had partial compliance for a week, compliance for 2 weeks, non-compliance for 2 weeks with this. And it's relevant because when we think about whether or not Mr. Wishart is safe, whether or not he's doing what he needs to do treatment-wise, this gives us the impression that he'll do it for a little bit, but then immediately falls off. And it's notable that in that original Awakenings SUD evaluation, it said he was ambivalent about the need to change. And that's sort of denoted here by his willingness to attend these groups. Also, very interestingly, the Kaiser evaluation says it's not just the groups that he's supposed to do. He's also required under that treatment plan to engage in random UAs. And you don't see any of those in the file whatsoever. It's not clear if he's just not doing them or if he's done them and he's just not providing those results. But we don't see any of them in the file. What you do see are the UAs that are self-directed by him, self-timed by him. So he's able to essentially clear his system, at least as to his UA, and then provide those results saying, look, I'm doing so well. But the hair follicle then undermines that, saying, well, actually, you're not. You're still continuing to use far past your clean date. And again, it's a concern that we don't have any of those random UAs that Kaiser indicates he should be doing. Either they're poor results for him, or he's just saying, I'm not going to do them. And because there's no indication that they have any cost whatsoever when he's doing them with Kaiser. So this really throws in a lot of issues with this. We have Mr. Wisher, who at this point has a long history of not being honest with the court. And we see back in April and May and June where Mr. Wisher is denying all substance use, and he's getting caught with cocaine not once, but we have 2 hair follicles with cocaine. We've got UAs with alcohol. His Awakenings UA that was part of his substance as SUD evaluation has alcohol in it. This most recent hair follicle indicates continued use of alcohol. And we have to remember, it wasn't just the court that Mr. Wisher was dishonest with. It was the guardian ad litem. It's the providers, where the provider in Awakenings is like, yeah, these stories don't line up. And when I'm getting a positive UA, his story really doesn't line up on his, ability to change, desire to change in his statements about use. So that takes us to, what do we do? This is a very young child. This is a child who's not, as a practical matter, able to self-advocate and to make herself safe. She would not be safe in sort of even a general household setting on her own. This, again, is a sort of toddler age child. My client, based on these most latest results and sort of some of the things that should exist and don't, is asking the court to maintain the current parenting plan, or maintain the current plan, I should say. It's not really a parenting plan, so I call it an interim plan. And that's Mr. Wisher is receiving a couple hours a week, supervised by my client's family. That needs to continue until Mr. Wisher is clean, until he's maintaining his sobriety, until you see compliance with the SUD evaluations, including the most recent sort of one that's cold without collateral input. Even that says he's in moderate risk, and there's no indications that he's in full compliance. We have some partial compliance and then just weeks with straight no compliance. And that does not indicate a strong pathway to sobriety that would result in regular unsupervised time. So the current plan for visits should remain. It's notable that Mr. Wisher never says that any of the supervisors who are currently supervising are anything but gracious and kind and welcoming and available. Visits by everyone's account are going well in the current system. And so again, there's no indications that anything's going poorly. This is a safe, quality environment that the child's doing well in. And this decision isn't based on Mr. Wisher's comfort or Mr. Wisher's desires. The focus instead is on the child's needs. And when you look at the hierarchy of need, safety is that base level. Child has a right to be safe and deserves to be safe. And the current plan is in the best interest of the child. And we hope that Mr. Wisher does become sober, but we don't have those indications yet. We have the indications that he's not going to the treatment that's provided for him, that he's just choosing not to do that. So again, in this case, we're asking to maintain the current order. We're set to review now out into October. That essentially gives Mr. Wisher about 6 more weeks or so. And I think at that point, then we can look at his compliance and his sobriety and see if he's maintained that. And he should be required to provide those random UAs and compliance reports. And those should be part of the guardian ad litem report. If these random UAs are out there, guardian ad litem should have them, and he should be required to provide them. If he has not done them and just declined to do them, he should also have to disclose that as well. Because I think that that's indicative of whether or not he's has a true intention for his sobriety or a intention to continue doing what he's doing and sort of just covering it up and taking the UAs when he knows he can get clean for a couple of days, but then partying when he wants to. So the current plan is working for the child. It's working for Mr. Wisher. He doesn't like it, but it's working. So we ask the court to maintain it. It's safe, it's practical, and it works.
Thank you. Ms. McLean.
Thank you very much, Your Honor. So first off, one of the difficulties as far as sort of doing this as a short notice shotgun with declarations that have just recently come in and now arguments by counsel that are sort of beyond her client's declaration is in regards to the arguments as far as the UAs from Kaiser. So first off, had I known that that was an issue, I would have directed my client to try and obtain those. I'm not aware of when or what UAs Kaiser has had him do on a random basis, and those certainly aren't outlined in the progress notes. But again, it doesn't indicate that he's not in compliance with that. Counsel goes through specific dates in regards to that progress note from Kaiser that outlines when he did, when he attended groups. And I apologize. Had I known that that would have been an issue, I probably would have attached another copy of my client's work schedule to his reply declaration so that that would have been a little easier for the court to follow. But if you could go back to his declaration that was filed with the court on July 20th of 2023, I had attached to that declaration his work schedule. And if the court recalls, he works 4 on, 4 off. When he works, his first 2 days, which are identified as ones on those schedules, are day shift. So he works from 6 a.m. to 6 p.m. And the classes with Kaiser are from 5 p.m. to 6:30 p.m. So he is at work, and he, as he tells you, he's been trying to work with his employer to get FMLA approval so that he can take time off work early or come in late when he works graveyard shift. And graveyard shift is identified as a 2 on his work schedule. And when he works graveyard shift, it's 6:30 p.m. to 6:30 a.m. And he works in Kalama, and so he has to leave here basically 30 minutes in advance in order to get there and then to get into his workstation, wherever that is within the facility. So that's why you see on the progress report, it indicates that he has the partial treatment groups of 60 minutes of a 90-minute group, because when he works day shift, he's not able to attend. He's at work until 6:30 p.m. When he works graveyard shift, he has to leave by 6 p.m. So he's leaving 30 minutes early. That's why they say it's 60 minutes of a 90-minute. When he has his rotation of days that fall off, when he's off, then he's able to attend the full session. So if you go back to that work schedule and look at Wishard, and if we start with July 31st, and let me just align myself here. So July 31st was a Monday and he was off. I'm not certain why they're saying that that was only a 60-minute visit. My understanding is that he would have had a full 90-minute visit. And he also had August 1 off, and I'm not certain why that's not referenced here. So, I mean, that's stuff that I guess I should follow up with Kaiser, because I'm unaware of that. If you go, so his classes are Mondays and Tuesdays from 5 to 6:30 p.m. So again, if you go to every Monday and Tuesday, on August 7th, he was working graveyard shift, so he was able to go to the 60 minutes, which is referenced. On August 8th, he was off. So my understanding is that he attended the full 90 minutes on August 8th. On August 14th, he worked graveyard shift, and it identifies that he was there. And the assumption is that that was a 60-minute session, and same with August 15th. I can't speak as to, so August 21st was a day shift. He wouldn't have been able to attend because work gets off at 6:30. On August 22nd, my assumption is that he would have attended. So I'm not sure why that's not marked. I don't know what records. Obviously, this was prepared as of September 1. So I'm not certain as to why it doesn't address those. I can certainly reach out to the counselor now that I'm aware that those are concerns. To be quite honest, I didn't compare those with my client's schedule at the time. What I discussed with him was why is it saying 60 minutes of a 90-minute session? And that was the explanation given work. So he's still trying to work with his employment to work on getting FMLA so that he can attend those. In regards to the drug testing, we did receive those after my office closed last night. And so we processed those out immediately this morning. In my discussions with my client, he did acknowledge having 2 shots of alcohol at his sister's wedding, which I think was 2 weekends ago, or would have been the weekend before September 1. And so he does acknowledge that he did have those. I was aware of that today for the first time in reviewing his test results. As the court knows, it's not uncommon for individuals to have relapses as they're going through the treatment process. And that's why it's important to have a treatment plan in place so that he's got counselors that can help him deal with those setbacks. Even Ms. Wishard in her own declaration acknowledges that she expects that there's going to be setbacks, and relapse and recovery are part of the program. It's a learning process for Mr. Wishard as well as every other individual who goes through sobriety and treatment and trying to navigate through the process, coupled with the fact as far as trying to navigate through court hearings and financial demands and the like. I'm pleased, and Mr. Wishard should be celebrated that he does not show positive for drugs, which his previously had tested positive for. I think that that's an accomplishment, and again, goes to the fact that the second hair follicle that Ms. Baldwin is relying upon, again, was part and parcel with the concerns that were raised by the testing agency as to why were we doing a second hair follicle with before a 90-day lapse in time frame. And so now we can see that the last 90-day period from the time of his first hair follicle to the current hair follicle, he has not used any illicit substances or any marijuana, which again, I think should be celebrated. Every step through sobriety should be celebrated. In regards to the alcohol, yes, he still needs to work on that. He needs to recognize what those triggers are. And that's part of going through counseling and the treatment and learning how to navigate social experiences like a sister's first wedding. And that while you want to be able to celebrate and having a shot of alcohol or two, in this circumstance, you're not allowed to, and that this is going to be the impact. My client obviously wants to continue to have a relationship with his child. When you go back and look at all of the visitation notes are positive. He has a very bonded relationship with his child. The child is happy to see him. The child is sad when the visit is over. The child expresses missing him, which again talks to his bonded relationship. So quite frankly, there has been no evidence that during any of the visits that he has been intoxicated or under the influence. There has been no supervisor that has stopped or terminated a visit. All of those have progressed, and the child's relationship with her father should progress. So we are asking that the court consider unsupervised visits. If you're not going to consider unsupervised visits, we're asking that you expand those supervised visits, because, you know, a couple of hours, a couple of times a week is really not sufficient for the relationship that this child has, and she's still outwardly expressing missing her father. I understand counsel's arguments about safety first, and obviously the supervisors have been there, and there have been no safety concerns that have been outlined by either of them. Obviously, if the court is inclined to have him provide, you know, it could be that I know that one of the things we talked about at the family law brown bag was the sober link. Maybe this is a case where prior to his visit, he submits to that, and to determine whether or not he has consumed prior to the visit. Maybe you do it before the visit and after the visit, so that he can have that unsupervised visit and not having to rely upon third parties, because that does take a lot of time for third parties. And again, there hasn't been a showing that there is a safety risk for this child. Ultimately, my client has asked that you consider unsupervised visits, and he's proposing for the next 4 weeks that he have on his second and third days off from work, that he have from noon to 6 p.m. And then 4 weeks after that so 4 weeks of the 6-hour visits twice a week or on his days off. And then the next 4 weeks, do an overnight visit from his second day off at 12 noon to his third day off at 6 p.m. And again, that would give Ms. Kale another opportunity to, you know, unannounced observe those if she so chooses and the like. But again, it's going to allow the child to recognize that dad does have a home, that dad does have a place where she can acclimate to, so that they're not always being in public. Because again, there's a comfort to having a home, having that security of a home cooked meal, having that security of, well, this is my room and I can roam and play and do these things within my household. I would also remind the court that my client continues to live with his parents. And so his parents are also adults that are available immediately within the household during those times as well. I would note that the 4 weeks of day visits and then the 4 weeks of overnight visits, about 6 weeks into that schedule, we would be back here on that October 24th date for the visitation review. And so we would ask that the court consider providing for that. In regards, although counsel didn't argue this, it was certainly in her client's declaration in regards to financials. My client has been struggling financially with all of his requirements. He has paid the $2,000 family support for August. That was taken care of last week. He has not been able to pay the $2,500 attorney fee or the $475 UA hair follicle test that were ordered on reimbursement at the very start of this case. Those accrue 12% interest. He would have had the benefit of no interest had he been able to pay those within 90 days. The hope and expectation is with the court's more recent temporary ruling of reducing his his family support to $1,500 per month, that may allow him some additional funds to be able to float towards those. But keep in mind that he is living on a shoestring. He's having a hard time keeping fuel in his vehicle, which is necessary for him to get back and forth to Kalama for employment, to provide transportation for himself to and from supervised visitation locations and the like. And as far as paying for the ongoing weekly UAs, which are very expensive. I mean, overall, those are a significant amount each week out of his pay. In addition, there's no information that suggests that Ms. Wishart isn't able to be employed, even part-time. as well as she has indicated that she's applied for school, but we've received no information as it relates to her financial aid package that she may have received and any additional funds that she may have received to supplement her and her child's living expenses through financial aid. So none of that's been forthcoming, and I would question whether or not those are financial resources available to her. So we would ask that the court deny any further financial relief. Mr. Wishart is certainly strapped. He needs to continue clearly to focus on his sobriety and moving forward. I'm certainly happy to work on trying to obtain copies of UAs from Kaiser. I had simply focused on the ones that had been required through the court order that he's been taking weekly, that I can't even remember the Lower Columbia Occupational Health has been forwarding to me by email. So those are the ones that we've been filing. And I guess I would apologize to Mr. Wishart in the court if I failed in following up on those. I was just, I guess, tunnel vision on the ones that the court had ordered.
All right. Thank you, Ms. McLean. Anything else, Ms. Baldwin?
Thank you. Ms. McLean tries to have it both ways. She says, gee, my client has to work all the time, so he can't go to treatment. And then she out of the same side of her mouth says, gee, he doesn't have any money. But if he's working the same hours and his excuse for not going to treatment is he's working, he does have the money to pay. And concerningly, we have dates where there isn't an explanation. He's not working and he's also not going to treatment. So again, we have these concerns. We have Mr. Wishart openly admitting he's had alcohol within the last 2 weeks. And the concern here is I don't see that on the UA. So again, that sort of raises a concern because weekends are usually, or weddings are usually on a weekend, and we don't see that pop up. And so again, that sort of leads to some integrity concerns. I appreciate counsel sort of trying to take the blame for not having the Kaiser UAs, but the reality is that those are completely within Mr. Wishart's control. Either he's just not doing them, and so the results don't exist, or he has done them and they're bad. And so, because I doubt if they were good, he'd be hiding or not providing them here. It's notable that there's no evidence he's asked for FMLA leave from his employer. And again, that notes again back to that Awakenings SUD evaluation that says he's ambivalent to change. And again, these UAs are so expensive, but there's no indication that the ones from Kaiser are expensive at all. And if he had free or very low cost random UAs, we're not saying he has to do multiple ones. No one has ordered that. It's only that he has to complete UAs. So I don't think anybody would have said, oh, gee, if you did one from Kaiser, it's no good. So again, concerns there was sort of, but the ones that are at occupational wellness, he can control and he can control the timing. So again, that goes into an integrity question. As far as safety risks, somebody being inebriated during a visit is an obvious safety risk. The reality is the supervisors provide a protective environment for the child. We have to remember that within the summer, Mr. Wishart no called, no showed, and no valid explanation, in my opinion, a visit. So that's certainly an impression that it would or could impact visits with child. And it's a very bizarre position to take where Mr. Wishart says, yeah, I violated your order, judge, give me more time. That's a bizarre position to take. Mr. Wishart has relapsed. He has not followed the evaluations that we had as of June from Awakenings. We don't see him compliant in treatment. We don't see him going to all of the other AA or NA groups that are available in town. So the same, well, gee, I couldn't go to Monday, Tuesday. Guess what? I'm pretty sure in town there's a group 7 days a week, multiple times a day for these types of issues that he could have attended. And while maybe that might not have been perfect compliance, it's certainly better than doing nothing at all. So again, Mr. Wishart is just ambivalent to his treatment. We want him to take his sobriety seriously. The child doesn't suffer in the midst of that. My client is saying maintain this order for the next 6 weeks, which is certainly not forever. And let's see where Mr. Wishart's sobriety is then. But that is a reasonable outcome for the child, is to maintain a system that's working, that's safe for the child, that Mr. Wishart himself can't really complain about. He just doesn't like it, but he has no actual complaint about the current visitation system. And for that reason, along with all of the others, we should maintain the current order. It is in the best interest of the child.
All right, thank
We're
you.
going to hear from Ms. Kale.
Ms. Kale, did you have something that you wanted to comment on?
Yes, just in my observations of Addison and Mr. Wishart together, as well as all the notes coming in from the visitation supervisors, her relationship with Mr. Wishart is very strong, and she repeatedly asks for more time with her dad. She has a very hard time leaving him. She has been in some counseling and has expressed missing her dad while in counseling. There is no question that there's an issue with substance abuse here. I am not in favor of Mr. Wishart having any kind of overnight visit without a sustained period of sobriety. But as Ms. McLean pointed out, Mr. Wishart does in fact live with his parents. And so I'm wondering if there's a way in which We can offer visitation that takes place at grandma and grandpa's house with dad, that doesn't require necessarily a supervised visit, but does offer a safe place. We don't have any evidence that Mr. Wishart is inebriated during his supervised visits. And that's not to, I don't say that to try to take from the fact that there's a substance abuse issue here. I fully acknowledge that. But in looking at best case situations for Addison herself and her needs and her desires and her wishes, I'm wondering if there's a situation that we can create for Addison that would allow her to be at grandma and grandpa's house. Also, she states missing her grandparents on Mr. Wishart's side of the family, where she can have visitation with Mr. Wishart in grandma and grandpa's house, where she has access to all of those things that Ms. McLean pointed out, the room that they've set up for her, the toys she has there, and to have an experience with her dad that is more comfortable and in a less formal setting. But those are my thoughts at this time.
Thank you very much. I appreciate that. Actually, I was considering going there. So I appreciate that was brought up. I know that there initially were some accusations of these family members, drawing a line in the sand between these two young folks. And to some extent, I suppose that's reasonable. But to assume that the parties would not have the best interests of this little child in mind is unreasonable. If that hopefully that came out correct. I would assume that the paternal grandparents would supervise sufficiently a visitation. There's been no contact with them that I'm aware of since this started. And I know there was some concerns about, I don't think any of the parents were suggested initially as being the supervisors, I guess, in this case. Here's what I'm gonna do. We're currently 4 hours a week, 2 different visits. Okay. I'm going to keep 1 2-hour visit supervised by Miss Wishart's family a week. And I'm going to allow 1 4-hour visit essentially supervised by Mr. Wishart's parents. So that would allow a visitation in the home. She can see her grandparents, see a room, play with toys, not be in a park. I would require paternal grandparents to do a brief report, just like every other supervisor has been required to do. File up.
I'll have them sign the supervision, the supervisor oath. Yeah,
perfect. And obviously, that we don't need paragraphs, but a summary of how the visit went. Things that go on. If Ms. Kale's able to check in on one of those visits, that would be great. And so he's only getting 2 extra hours a week, but 4 of those hours are now supervised by his parents, so that can be in the home.
So is there any way that we can schedule like a consistent 2-hour visit and a consistent 4-hour visit that align with his work schedule? Because having to negotiate these has really been difficult. And most parents have on his second day off, he's going to have from 4 p.m. to 6 p.m. And on his third day off, he's going to have from, 4 p.m. to 8 p.m. or whatever. I'd like to have some consistency because eventually we're going to get there, but that way everybody knows what to expect when and to have somebody prepared for that.
And so the reverse of that is it is not reasonable that everything is dictated by Mr. Wishart's schedule. Again, we're in this position due to Mr. Wishart's choices. And my client, there is not, it's very clear that my client and her supervisors have been very consistent, that they've provided visits. Again, there's really no complaints within the materials that like somebody didn't schedule a visit. And so to say, oh, this has been a problem, nothing indicates that. So it isn't reasonable to say Mr. Wishart can dictate how this happens. The parties should continue to have to negotiate as they have done and as they've done successfully for the last couple, since the court's last order. So it isn't reasonable to say again that Mr. Wishart gets to dictate this and that my client and her supervisors have to then bend to his desires. I think this is a collaborative process and both parties need to have input, not just Mr. Wishart and his schedule. My client and her supervisors have schedules too.
Yeah, but the child thrives.
Okay, here we are. I know the child's not in school and I know there's issues. I'm not going to, it's almost 5 o'clock. I'm not going to sit here and try to go through the schedule that to me looks like Morse code and figure out what works for all the parties. I do think that is appropriate to try to get some kind of a regular schedule set up that works for everyone, not just one side. And I guess, Ms. Kale, I'm going to task you with seeing if you can either determine a days of the week or a cycle that may work around Ms. Wishart and Mr. Wishart's calendars and any family activities that are kind of reoccurring. But at this point, I think until we come back on the 24th, we're going to status quo as far as scheduling those. But I am expanding the visit, and so instead of just 4 hours a week, we're up to 6 hours, and 4 of those hours can be supervised by Mr. Wishard's family. Obviously, he needs to work out the time of that with Miss Wishard.
Are we continuing the weekly UAs?
Yes, I mean, I think it's appropriate, and I think I'm not going to suggest that anybody is being nefarious. I understand the concerns of Ms. Baldwin because, I mean, as she stated, we're kind of here where we are for a reason. So if I guess I would want an update from Kaiser. How many UAs is he taking at Kaiser?
Sure.
Is it once a week? Is it twice a week? Are they random? Are they?
I'll follow up on that.
And then I'd want all
Honor.
that information, and I want Ms. Kale to have that information as well. And I will state that I am happy about the hair follicle. In generally speaking, I do. I am glad that it doesn't show illicit drugs in his system, and my hope is that I think alcohol is a difficult drug to deal with, and because it's frankly just prevalent and so easily available, and there could be ongoing struggles with that. But I think given the history, we need to just be as prudent and thorough as we can be. Ms. Kale, I'm sorry I interrupted you.
No, Your Honor, I think I actually interrupted you, but thank you. Yeah, I was just going to request from Ms. McLean, and I can reach out to Mr. Wishard about being included in those to find out about the Kaiser UAs, because I'm also very curious. I was also, I know this is a touchy subject to bring up here at this point, but I've almost exhausted the hours that have been allotted to me for this case. And so I know that it's getting tight for both parties. And so I just want to cautiously request maybe 3 more hours to work on this visitation and wrap up the report.
Any objection?
So my only issue is the additional work is basically solely based on Mr. Wishard's choices. And so my client is sort of financially along for the ride when she has substantially less income. So I'm fine with the extra time, but I do think it should be at Mr. Wishard's time.
Well, again, he's been providing substantial income to her, paying substantial expenses for her, as well as having his own expenses dealing with his substance abuse issue. So I think that they are both in the same situation, and I would ask that the court order the continued percentage split.
Anybody know what that percentage is off the top of their head?
60-40, Your Honor.
I think 60-40 was the last JL order.
All right. Here's what I'm going to do. I'm going to authorize your additional 3 hours. I think that's important. And if you could just submit your bill, and then we're going to review that on the 24th of October.
Yes.
And I will determine on the 24th, essentially allocate that those additional 3 hours
Okay.
on that date and time.